Good evening, good evening, good evening, amazing Law Nerd. We're back. Take two for today's stream because take one had its own little quirks, which I am pretty sure we have worked out, but we'll find out together as we go. So thank you all for your patience. Thank you all for staying in the loop with what was going on in the app. I appreciate you. We tried to save all the super chats from this morning, so some of those will be answered from the morning stream and the evening stream. If you hear the sky rumbling, that's also at my house. Today has just been an adventure. And guess what? We're going to just roll with it because what else can we do? So we're going to finish what we were planning on this morning. I know that sound was a little rough early on. The hearing we got through part one, the morning hearing. We are going to be back to take care of the afternoon hearing from yesterday's hearing on former Trooper Michael Proctor's procrastination of deposition because there is so much going on. We took a poll in the morning. We're going to roll the intro. We're going to do a roll so far. Roll so far? Yep, we're going to roll with it. We're going to roll so far. We're going to do a road so far of where we were in the morning hearing. We're going to then look at the Today Show interview that we had voted on in the poll. And then we are going to go to the afternoon hearing and then some of the dockets that were filed yesterday. Since I've been fighting with my computer, I haven't looked. If there's any new dockets this evening, maybe we'll get to those too, because whatever, we're already here. We're gathered together this evening. I have a Dr. Pepper because that was needed. I had an appointment that was non-negotiable today, which also delayed me. We've got a Dr. Pepper. We're ready to roll. We're ready to roll. We're just ready to roll. So Law Nerds, we're back. And we're gonna do a road so far. So for those of you that were not here this morning, don't worry. I will try to bring you up to date. For those of you that were here this morning, well, I'm sorry for the cliffhanger. That was not what I anticipated. I am whatever. What can we do? We're here now. I'm annoyed, but you know what? It's gonna be fine. It's all gonna be fine. It's gonna be fine. It's gonna be fine. And for those of you that were very kind and they're like, girl, how do you stay calm? Look, there's only so much I can control in this life. And sometimes we just cannot get that fussed about things we can't control. Is it annoying? Yes. Is there anything I can do about it other than what I've been doing? No. So look, I also think the perspective of working in the DA's office for quite a long time on the scale of things that are like worth freaking out about. This is frustrating. I am annoyed. I am frustrated to screw up y'all's day because it was like, well, we were going to have a stream and then the time changed. Those things frustrate me very much. But at the end of the day, we can control what we can control. The replay crew will be replay crew. Good to see you. And we roll with it because sometimes the tech is teching and we just have to make it work. I mean, yelling at the computer is not going to make it go any faster. So what are we going to do? But I think we figured out what was going on. And again, I had a supervisor who every time I would, as a very young DA, go into her office with my hair on fire before I realized that I had to just stop being so stressed about things because otherwise it was, well, ultimately caused some health issues anyway. But she was like, it's all going to work out. It might be stressful. It might not be pleasant, but it's all going to work out. It's all going to work out. It's all going to work out. So it's all going to work out. And you know what? We weren't in trial. So, you know, we're glad for small favors because that would have stressed me out a whole lot more. So I'd rather have these hiccups happen when we're not in trial. Streaming is dynamic. It's going to be great. It's going to be great. Let's roll the intro. Let's do a road so far. Let's do all the things. And we're back. Everybody, we're back. Cheers. I actually, Emily, you're going to roll the intro. I was thinking of Ryan Hall because as I was driving home through the severe storm warning, I was just thinking of Ryan Hall, y'all being like, somebody's got to get their Wendy's. Today it was me. I had an appointment. I wanted my Wendy's Dr. Pepper. It's been a day. I don't drink soda all that often. So yeah, I mean, I didn't leave in the severe storm, but I had to get home in the severe storm. We had to stream. we had to stream. So here we go. Everybody, let's roll. Shall we? Let's go. No, it's not. We're not doing that. One more time. Let's go. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, you guys, so you know what's happening. No law degree required. Please. So join the law nerds in the chat. They're here for the facts, not and let's get to court. Tell me that sounds better than the morning, because this morning all of you were just like, holy moly, great. Look, things are already looking up. Things are already looking up from the morning. We're doing a little happy dance there. Fantastic. Look at this. Look at this. It's been a while since we've been together in the evening, and already things are going well. For those of you that did not catch the morning stream, my computer said, "Not today, motherfucker," and just stopped. Just stopped. The amount of time it took me to get it to even restart, it just was like, nah, we're not doing this. We're done. My computer actually had enough with the fuckery, I think is what happened. And it just completely crashed out. And I wasn't even crashing out that hard. I was mildly crashing out. The computer fully crashed out. I think we have figured out why. Look, we have gone through over here at Baker Media quite a lot of growth and tech changes and running our own software and running our own court feeds as we can. And every now and then that comes with some hiccups, and we hit one of those hiccups. I think I figured out what the hiccup is. Now we will figure out a solve for it and it will be fine. But yes, my computer, oh wait, do I still have "not today, Judge" in here? That is exactly what my computer did today.
Not today, Judge.
That's what happened.
Not today, Judge.
That's exactly what my computer did this morning. Which, valid. I was so sad. I was so sad because I wanted to stream with y'all. So let's talk about what happened during the morning. We watched the AM hearing from yesterday. These are the hearings regarding former Trooper Michael Proctor's procrastination, because remember, former Trooper Michael Proctor wanted his deposition that was supposed to be taken on Monday, June 8th, delayed. And they filed at the end of the day on Friday, which really just isn't enough notice for anybody. So they filed at the end of the day Friday. The court said, hey, everybody, you have till 5 p.m. on Sunday to explain to me WTF. That is my summary. So when they got into hearing at the beginning of the morning, early in the morning on Monday, they get into this Zoom hearing. After their own technical difficulties, the court asks about the impoundment, which is the sealing of the records. The Karen Reed's attorney, Seligson, said, Your Honor, I can understand why some of this information, seemingly regarding personal medical information, I can understand why some of this information is sealed, impounded, but the rest of it doesn't really need to be. And then the defense, Michael Proctor's attorney, spoke up and said, hey, so we think the whole thing should be impounded, and then had a moment saying, and, well, hours after this was filed on Sunday and emailed to the clerk, mind you, this never hit the public docket, ever, not once. It never hit the public docket. But the defense made a point of saying, hey, Your Honor, after this was filed, former Trooper Michael Proctor and his family started getting harassing phone calls talking about things, the content of which is in the affidavits and the documents that we filed, which is exactly why they need to be impounded. I pressed X to doubt. I have questions, but that's what they said. So I am telling you what they said. The court held a hearing, briefly heard from the parties, wherein Karen Reed's side said, hey, we think the deposition should go forward. And if it doesn't go forward and the court puts it over, we think you should award costs, attorney's fees, etc. So then the court says, I'm going to take a break. Took like a 30 plus minute break, came back, and the court read into the record a document that has since been posted on the docket, but read into the record that subpoenas have to mean something, and keeping your attorneys informed as a client needs to mean something, and attorneys' words need to mean something, and the agreement on a date needs to mean something. And I was like, yeah, Your Honor. And then the court went, however, and shit went sideways from there, because then the court went down a road of however. We think that attorney civility includes giving one another a heads up, and the court was frustrated that, though not obligated, Karen Reed's attorneys did not give Trooper Michael Proctor's attorneys a heads up that they were filing an action that he is not a party to against MSP and the town of Canton. And yes, his name comes up quite a bit. Yes, he is the cause of that cause of action, but no, he is not a party to that cause of action. And this is regarding former Trooper Michael Proctor's text messages, which are on his phones and from his iCloud, and that he, because we've seen no evidence to the contrary, that he wrote. In fact, as I mentioned this morning, when I crashed out about this then, they did a bunch of litigation in one of the criminal cases regarding whether or not the protective order would be embiggened so that those very phone extractions can be used to sue MSP in the town of Canton. And former Trooper Michael Proctor's attorney objected. They filed motions to object. And then they told everybody in this case, in the wrongful death case, they told everybody that they were going to be filing against MSP in Canton, and everybody knows that there is a waiting period for government entities. Everyone knows that. That period may vary, but attorneys in Massachusetts should be well the fuck aware of what that filing period is. 6 months, as it turns out. And then the court is sitting there looking at the attorneys going, I think you should have given them a heads up, though there is no obligation to do so. And so the court then basically said, I am going to reserve my ruling until 4:15, after he commented on the strategy that apparently he read a media article. Which media article, Emily? I don't know. He didn't cite it for the record. I have no idea what the judge is reading. But he read media articles about Karen Reed being on the Today Show on Friday, and he seemed real fussed about that. So then we put up a poll and decided to vote on whether we would watch the Today Show interview first or if we would go to the ruling at 4:15. So where we left off was with the judge putting all the attorneys in the attorneys, Your Honor, all of the attorneys in a timeout for the entirety of Monday. Because I think most depositions are probably scheduled around 10 a.m. Court was done before 10 a.m. Could they have said right then and there, hey, go do your depo? Sure. But that's not what the court chose to do. What the court chose to do is say, y'all didn't give me enough information, Trooper Proctor, and y'all were on the Today Show saying some shit, and you didn't give us a heads up. So I'm gonna have y'all come back at 4:15, and gave Trooper Proctor's attorney another opportunity to file more information. So everybody got put in timeout for the entirety of the day on Monday. And then they came back at 4:15. But I haven't watched this Today Show interview. I read a headline or two about it. I don't even think Karen Reed talked much about the new lawsuit in it. So, Your Honor, with all due, WTF's the deal? And also, what article did you read? Also, what does it have to do with anything? So that is where we're at the end of the morning on Monday, with the judge putting everybody in timeout until 4:15. You know what they could have done between 9 whatever Eastern time when they finish this court hearing and 4:15? You know what they could have done? A fucking deposition, or at least made a start. And if the court hadn't called them back at 4:15, the court could have said, go do your deposition. But that's not what the judge did. So let's go see what the Today Show had to say, because the judge is like, Karen Reed was sitting on the Today Show with her lawyers, the very lawyers that are in the room. I mean, Alan Jackson was kind of in the Zoom. He was frozen 90% of the time. You gotta travel with a mobile hotspot if you're gonna Zoom or stream from hotels. I have fought that fight a couple of times. It's no fun. Do y'all remember what trial were we in? I was trying to go see Dave Matthews. Emily, it was summer. Is water wet? Yeah. But I was trying to go see Dave, and even the mobile hotspot was like, there was no cell reception. I was trying to we were going to Alpine. Was it Karen Reed? It was probably the Karen Reed trial. It probably was. It was probably the Karen Reed trial. I think it might have been Karen Reed 1. I think it was probably Karen Reed 1 when the jury kept coming back and doing stuff, and the mobile hotspot was like, I don't give a shit. And I'm like, I just want to go watch Dave. It probably was Karen Reed 1, because it was right after I had gone to VidCon and the concert. There was weather and my hotspot my Verizon hotspot didn't have good reception either. It was real frustrating. It was real frustrating. Real frustrating. But anyway, memories, law nerds, memories of trying to stream on the road. It's gotten better since then, our on the road streaming. I also don't do it nearly as much. All right. So that's where we were at the end of the morning. We're going to watch the Today Show interview with Karen Reed and her attorneys that apparently the court is so flustered about. We're going to fly to Massachusetts first and see what all the hullabaloo is about. And then we're going to watch the afternoon, and then we're going to read all the filings that we haven't gone over yet. Sound good? All right. Cheers, Leonard. Let's fly back to Logan, shall we? We're going to get lots of frequent flyer miles today. The turbulence should have given something away. From me. Where is my pen? Fred! What have you done with my pen? Oh, there is no doubt that cat has knocked that pen off my desk, and it is somewhere. We're going to get to the Today Show interview. I'll figure out what the fuck Fred did with my pen in a bit. Are we going to do it now? Nope. Did that totally get swatted off of my desk by Fred? It totally did. All of you are like, Fred's innocent. Look, man, that is hallmark Fred behavior. George doesn't want to knock things. George is not a knock things over type of a cat. Fred is a pay attention to me type of a cat. I'll find it. I have another pen, thankfully.
About the people who serve in that department.
All right.
And joining us now is Karen Reed, along with her two attorneys.
Words aren't even working this evening. New interview. The attorneys look thrilled. New interview. That's what I meant. And this was from Friday, June, whatever the 6th, 5th, 6th-ish, 5th, somewhere in there.
Serve in that department. And joining us now is Karen Reed, along with her two attorneys, Alan Jackson and Charles Waters. Good morning, everyone.
Good morning.
Karen, let's start with you.
Yes, Charles Waters was in the hearing that we watched this morning. He was sitting down in a box with no light. You could barely see him. Man does not have a desk lamp, apparently. But when the court started saying things, he was barely restraining his face, going like, but he was in that motion as well.
Because we really haven't heard from you much and seen you really at all since the jury's not guilty verdict.
Well, apparently that's not enough for the judge, because any seeing Karen is apparently a problem, even though there's no non-dissemination order and the court can't restrain Karen Reed from talking about her cases unless there is a non-dissemination order. So what are we doing? But I digress.
First, just why file this lawsuit now? You already have one lawsuit in the queue. Why do this now?
Because you have a statute of limitations.
This was always our plan, that I had to save my own life first. I can't do anything if I'm not free. And I had to fight for my freedom for years. And I knew as it unfolded. I was never going to be able to just forget that this happened to me, that I was wronged in this way. I couldn't just go back to life as it was. I have to continue fighting for justice. The acquittal is deserved, but the wrongs have not been completely righted. They've been happening along the way, but I always knew this was going to happen if I could get the help legally to do this.
Let's talk about that for a moment, Alan, because
Which, by the way, is her right. And for the court to say, Karen Reed said this was always part of the plan, you can't bring a malicious prosecution action unless you're acquitted. Some of these actions don't get brought unless you win in criminal. So no, you're not going to sue the police department while you're in the middle of a criminal prosecution. And then the prosecutors chose, after a hung verdict, or a hung jury, they chose to go back and prosecute her again. So yeah, you have to wait till now to prosecute this. And she has the support and the fleet of attorneys to do so, and the texts and the downloads and the federal investigation and. Yeah. But what, Your Honor, yeah, this was always part of the plan. We know. It wasn't ultimately part of the plan. I don't think she ever had a plan to get arrested and prosecuted twice. And for this investigation to unfold the way it unfolded. But after you're acquitted, yeah, suing the police department has got to be part of the plan. There's nothing nefarious about that, Your Honor. People are allowed to sue when wrongs have been done to them. I don't know. Okay. But anyway.
again, as we just saw in Laura's story there, Sergeant Good's fired.
Right.
Lieutenant Proctor fired. They're both gone. The department's
Former Trooper Michael Proctor. But all right.
have said that there was wrongdoing. They've admitted that. From a legal standpoint, what do you precisely want to see happen here that has not?
I'm going to let them answer. I know exactly what I would like to see happen. But I'm not going to directly quote the things that that Trooper Proctor wished upon others in his text messages. But cuz I wouldn't do that. But I think a full flush of a department is needed, and you have to take a look at how many people just retired, like, oh, we're out, and ask some questions. And the cases that Trooper Michael Proctor investigated should be looked at. I mean, there's a unraveling that needs to happen here, and you're not going to see that without some lawsuits, are you? I mean, apparently not. What do you want to see happen? The people who did harm be held to account legally is the beginning. And if the department's new, then they're going to have to pay because it's a civil case. You pay for the harm that you cause. As the County of Los Angeles, they're really well familiar with paying for shit. But okay, the question is, what do you want to see happen?
Already happened. Well, it's a civil case, so the remedy is
money.
The law speaks in dollars, but that's not what the ultimate goal is here. The ultimate goal is to ensure that we bring to the light the institutional biases, the institutional corruption that permeates the Massachusetts law enforcement system. That's what this lawsuit's going to do. Ultimately, what Karen wants, you cannot write on a check, which is exposure of the corruption that is the DNA of the Massachusetts State Police, of the Canton Police Department, which is evidenced by these two individuals in their text messages, they were in a position where they felt comfortable within their own family, the family of law enforcement, to send these vile text messages, to send these vile voicemails that are reflective of a deeper problem in the culture. That's what we want to expose.
What I would like, and what I've said from the beginning of trying to watch this case with y'all, is I would like to understand what happened. I don't know if we ever will get to a court hearing where we get to the end and we're like, okay, I understand a bit more what happened. I understand what went wrong in this investigation fairly well. I understand why ARCA was brought in, but I'd really like to know more from ARCA, and I'd really like to know more. I'd like more answers. At the end of the day, I would like more answers. That is not necessarily what we're going to get. And this lawsuit against the police departments are holding them to account for where they're not doing their jobs and holding the people in positions of power and with, weapons and the authority to arrest you and take away your freedom, holding those individuals to account. But I digress.
But to be clear, we're seeking money.
At the end of the day, that's what the civil law requires. Yeah.
Charles, I want to bring you in here because you guys have always maintained she was framed, right? That's been your entire theory from the beginning here. But what evidence have you actually amassed over the past 4 years now?
What is happening? Huh? Okay. Okay. They just sued the police department. Why are we not talking about the police department that we sued? Okay. Okay.
What evidence do you have to support that claim?
Well, I think that Alan, during the criminal cases, let the whole world see the evidence that she had. But I think, first and foremost, you look at the injuries that John O'Keefe suffered, and that, to me, is the key. Those were injuries from the back of his head. He died from injuries to the back of his head, some ridged lead surface.
But you've had that for a while now, right? That's not new.
I don't think anything needs to be new to sue the police department, though. You don't need any new information to. Are we talking about the new lawsuit? Because the new lawsuit's like failure to supervise, and questions I'd want to know is like, when did the police department know about these conversations? When was the police department aware that Proctor was like, hey, I saw a multi-car pileup. Go ahead and take your time. Let them die. Appalling shit. Hey, what does his personal file look like? How many complaints have there been? Those are the things I want to know in light of a new lawsuit against the police department. Those are the questions I'm curious about. But the things that came out in trial said to a jury, so hey, you definitely didn't prove that John O'Keefe was hit by a vehicle, because if a jury thought that John O'Keefe was hit by a vehicle, then a DUI causing injury or a vehicular manslaughter is a pretty easy charge if a jury believes that she was intoxicated, which they believe, she was driving, which they believe. But if they thought he was hit by a car, then you naturally get to DUI causing injury, DUI causing death at a minimum. But like there were 2 whole trials, and okay.
But the question was, what evidence is, and you start there. And when you start there and you realize that the medical examiner, for example, testified at the criminal trial that these injuries that he had were inconsistent with the car strike.
Twice.
So you start there, and then you say, what else could have happened? And then you look at the house. And then you look at the people that were in the house, and there are ridged.
I don't know if I necessarily agree with him on this, but we'll get to it. And of course, I think some of the testimony at trial goes with hard surface. I don't necessarily think it has to be ledged, but that is neither here nor there, because hard surface is exactly what all the evidence showed. However, where's this lawyer been the whole time? Like, I am so curious how this happened, that this is the lawyer. Where's dude been? I'm so curious. Who's the new guy? How did we get here? But also the questions are kind of wild. She just filed this lawsuit against Mass State Police and Canton Police, and it's wild. And then the question is, hey, what evidence have you amassed? Did we watch the trial? Maybe we didn't watch the trial. Okay. But okay. Mr. Waters, hello. Nice to see you. I'm sure he's been on the case for a while, but we've seen Seligson and Rosenberg mostly, and then Jackson. So I'm just curious.
Surfaces in the house. There are relationships that John O'Keefe had with people in that house that were difficult relationships.
I'm real curious.
And there's
about
a lot of evidence
more information
that
on
we've
that.
uncovered and that we're going to still uncover in this civil case.
Karen, let me come back to you for a moment here, because since the two trials, like what has life been like for you? I know you lost your house, you lost your
Are we going to ask about the police department or no?
car. Are you working right now?
No, I'm not working. I still don't have my license, and I'm back working.
I mean, God, if you're Karen Reed, do you want to ever drive again? Do you want to drive again? Also, no, her license is probably still suspended from the DUI. But would you ever want to drive again?
Working on the case, and we've brought in civil lawyers, but this case is so comprehensive that we need all hands on deck. I mean, I'm working on the case every day, and I don't know that I really ever took time off, and I don't know that I felt like I wanted to take time off. I want this to be over, but it's not done yet.
I would imagine, and this is just my speculation, I would imagine that Karen Reed is the one on the legal team, and it seems that her legal team trusts her from everything that we've seen about these cases. We know that she was a financial analyst. Karen Reed herself in interviews has said that she's incredibly analytical. I imagine that the first person spending the time to go through the entire cell phone dump from former trooper Michael Proctor is Karen Reed. I imagine that she is doing a lot of that heavy lifting because A, it will save her in costs down the road, and B, because she's capable of doing it. So yeah, I imagine that she is doing a tremendous amount of the legwork in this case, not only to keep legal fees down, but because, well, she's going to want to know anyway. I imagine that as the participant in this litigant, she wants to know every single thing that's going on. So yeah, I imagine that she is spending day in and day out, but can you imagine having to sit down and go through Proctor's phone? I wouldn't want to do that. I don't want to do that.
Because we saw the throngs of supporters who would show up at that courthouse who clearly believed, just as the jurors did. But you have to know that when you walk down the street, there are lots of people who look at Karen Reed and who think, oh, there's that woman that got away with killing her ex-boyfriend who was a cop. How do you go?
This is the interview that the judge was mad about. What is this this is the interview that the judge is mad about. Did I hear that correctly?
Believed, just as the jurors did. But you have to know that when you walk down the street,
I have to back. Where is the beginning of that? Where is the beginning of this question? Huh?
Ever took time off, and I don't know that I felt like I wanted to take time off. I want this to be over, but it's not done yet.
I want to, because we saw the throngs of supporters who would show up at that courthouse who clearly believed, just as the jurors did. But you have to know that when you walk down the street, there are lots of people who look at Karen Reed and who think, oh, there's that woman that got away with killing her ex-boyfriend who was a cop. How do you go through life knowing that there are lots of people who, despite what the jury said, still think you did it and you got away with it?
How did she maintain her face during that question? That's a lot of a question. You know, walking down the street, there's a lot of people that just think you got away with murder, girl. What's that like for you? Sir, I worry that you're spending too much time on Twitter. Who wrote these questions? I don't know why my phone needs to chime in, but it has questions too.
Lots of people who, despite what the jury said, still think you did it and you got away with it.
It's wild.
I've not had any evidence that there's lots of people who feel that way. I mean, I have lived more low-key in the last year. I've just struggled to not have the adrenaline that I had during trial. But I have no interactions, no matter where I go. The grocery store, a restaurant, Newbury Street in Boston, any hotel or restaurant I eat at. I don't pay for meals. I get discounts everywhere. My parents get help taking groceries. I don't have interactions. I have not seen lots of people. I haven't seen one. The support isn't relegated to what you saw at the courthouse. It's throughout Massachusetts, and it happens when
that was a rude pause. Hold on. I don't understand this question at all. I also understand that there are probably many in Massachusetts. No matter what you think of Karen Reed, I would hope that there are many that can look at Karen Reed, and even if you do not have the fondest of feelings for her, look at what's going on with law enforcement and still say, okay, well, Karen Reed aside, I've got a lot of questions. And from those that live in Massachusetts and locally that have reached out to me, the overwhelming feedback that I got is, no, people know that this is what it's like. No, people know. This is not a shock to people who are local. And I think there's many of people who are local who also want to see light shone on what is happening, whether or not they like Karen Reed. Also, I don't think criminal defendants have to be likable to still have wrong done to them. That's just, this is a choice. So maybe it turns around. There's not much interview left, but maybe it turns around.
Not one. Well,
he's shocked. Look at him. He is shocked. He's like, what? People don't yell at you on the street? He's stunned.
And relegated to what you saw at the courthouse. It's throughout Massachusetts, and it happens
so you've
when
never
I travel.
heard from one person who...
Not one. Well, there were people...
Have you been on the internet?
Sir, have you been on the internet? This is not serious. You are not serious. Have you been on the internet? Sir, have you been on the internet? So Okay. And well, I mean, I guess it was a good time for a reminder of why I basically do not watch network television anymore. This was a super helpful reminder. I don't think, first of all, the first time I thought she did this interview, I said that she did an interview on GMA because I didn't recognize the difference between the two. The last time I've really thought about the Today Show very much is everything going on with Nancy Guthrie. That's really it. That is the most I've thought about the Today Show in quite a while. But interesting that the day after this explosive lawsuit is filed, they go on the Today Show and the interviewer is like, isn't it true that people on the internet are mean to you? And this is what the judge is mad about? Oh my God. Bets on Karen Reed never going back on the Today Show. I imagine that this is kind of the end with NBC then. Yeah.
I mean, have you looked at any of the
Oh, yes. Yeah, okay. I've seen tweets. I have not interacted with anyone. And yes, there were people, there were pink shirts, and there was maybe for every 50 pink shirts, there was someone in a blue shirt who had many of them ties to people on the other side of this case.
John, let's talk about John for a second, Karen, because you dated for 2 years. You got so close.
So we're not talking about the new lawsuit. We're not talking about the new lawsuit at all then. No. Okay.
With his family, his nieces, his nephews. You went on vacation together, right? This is somebody that you loved. And yet, I think for a lot of people, somehow he gets lost sometimes in this conversation.
Well,
you have an app.
He's not lost. Okay. He's the reason we're doing this.
I think people sometimes wonder, are you doing this for John, or are we trying to go after institutional corruption? Are we trying to get you?
Is there a problem with it being both? Because since the very beginning of this case, I have been shocked at the way this investigation happened, especially considering that the victim is a cop. And there is probably way more history and divisions between these departments than clearly I am aware of. But one would think, and though it shouldn't be the way, one would think that if a victim is a cop, the rollout to that is going to look a little bit different than if it's just about anybody else. And I'm kind of shocked that it wasn't. I'm kind of shocked by the way the whole investigation went down still. And the more layers that are uncovered, you just sit here and are like, what is happening? But no, sure. Okay. I'm curious to see what the answer is to this, but yeah. Getting answers at the bottom of what happened in this investigation would also therefore get answers for John O'Keefe, one would think. But I don't disagree that in most criminal cases, the criminal process is in fact focused on the defendant's rights before it is focused on the victims. Absolutely. That happens in every case because the rights are different. And it can be very frustrating for victims' families. Absolutely. But this question is also kind of wild.
Money damages. What is the goal?
John
to find out what the fuck happened?
Victim of this institutional corruption, and we're the voice for John. And I have lived nearly daily John's final moments, and what happened to him, what was on his phone, what was the temperature of his phone, what was his interactions that I had experienced prior to his death with
I think this interview, that answer on this interview is going to come back in some of these suits. Her saying, I have lived nearly daily with John's final moments. I'm sure she met well, I don't know what she meant, but one would think that she, as she's talking about the phone, has been spending time thinking about what happened in those final moments. However, that's going to go into court and be argued a different way for sure. However, it's going to be much easier for Karen to answer those questions in civil suits now that all the criminal is done. But that's going to happen for sure.
Members of the.
So I'm going to back up and let her answer fully. But that answer, and this is lawyer Emily thinking, right? The strategic side of it. Why is the judge mad at this interview again?
What is the goal?
John was the victim of this institutional corruption, and we're the voice for John. And I have lived nearly daily John's final moments and what happened to him, what was on his phone, what was the temperature of his phone, what was his interactions that I had experienced prior to his death with members of the family that lived in that house. And this all revolves around John. I can speak about my personal memories with John, and his family can speak to them as well. But I implore any one of John's family or friends to point to any moment that I wasn't loving or caring with John and his adopted niece and nephew. And
what was he like?
John was very easy.
I mean, I get what she's saying. Lawyer Emily is like, oop, nope. That one, the lawyers on the other side are absolutely going to note down and be like, John's final moments. To me, it seems that she is saying, I have been going through every piece of evidence I have to try to figure out what happened. That's how I interpret it with full. But also, lawyer brain is like, oop, that one's going to get argued. But again, I can understand why she wanted to give an interview about the new lawsuit, because that was the headline of this story going into that. But that's not at all what they're asking her about. They're asking her to relitigate, it feels like to me, the trial, which is odd given the new lawsuit. Wild. His questions are all just rolled up. I would love to see what's on that paper. What are we doing?
Easygoing.
We're back to what was John like. Okay.
Implore any one of John's family or friends to point to any moment that I wasn't loving or caring with John and his adopted niece and nephew. And
what was he like?
John was very easygoing and kind of shy, quiet. And he just liked to watch Boston sports and drink a few beers. And he was funny. He had a really good sense of humor. And he was very dutiful to his niece and nephew. I mean, he did everything. They were involved in anything they wanted to be involved in. And he tried incredibly hard with them and gave up his bachelorhood, changed his trajectory on the Boston Police Department to care for them. So he was incredibly sacrificial.
We know you're fighting the civil suit that's been filed by his family, but if you could talk to his family today, what would you say to him?
Nothing. There are a lot of lawsuits. There are so many. There are lots of lawsuits. Why are we not asking about the new lawsuit?
I don't have anything to say to his family. I interacted with them for several years. John and I had actually dated a long time ago when we were in our early 20s, and I was caring and I believe generous with them, with my time, and we did spend a lot of time together. And they experienced who I am, and they know who I am.
Beyond the civil suit, what comes next for Karen?
Didn't y'all have her on the show to ask about the new civil suit? Do we know that the package going into the interview was about a new explosive lawsuit. But are we not gonna ask about it? No?
And Reed, what are you going to do for the rest of your life?
I don't think we're done discussing law enforcement, corruption, what's wrong with Massachusetts.
Ma'am, you haven't even begun to discuss it in this interview because they haven't asked about it. What's your day-to-day like? What comes next for you? 4 more years of litigation. Years and what comes next for Karen Reed is years and years and years of litigation. Unfortunately. What's the rest of your life look like? This litigation. Okay.
Where else is it?
So let's say you win the civil suit. Then what comes next for you personally?
Which civil suit? There's 4.
Personally, I'd like to keep talking about what I've experienced. I haven't really been free enough, especially with all these lawsuits, to say all that I've experienced. And I think it would be a waste for me to just disappear and go live on an island, although I would like to do that.
Well, we hope that you will come back. We have a lot more that we want to discuss with you as this case.
Yeah, I don't think that's going to happen. We would love for you to come back. There's a lot more to discuss. You had her there to discuss it, and yet you chose to not to. Oh my God. We sure hope you'll come back. Yeah, I don't think that's gonna happen. Yeah, nope. Wait, where is it? Where is my David Yannetti nope on the soundboard? Because we need the nope. Hold on. Where is? I'm gonna hit the wrong. I don't want to hit the wrong button. I would like to actually, figure out where I moved things around.
Nope.
Right. Yeah.
Nope.
Yeah, that's a no for me, dog. Everyone in the chat who said it, that is definitely a no for me, dog. So, Karen, what's up for the rest of your life? What are 4 civil suits, Bob? That was wild. Also, I don't know what she said in that interview that the judge could possibly have been flustered enough about to bring it up from the bench and in a written order. This was always our plan to sue the police department, right? After they won the criminal suit, I imagine that that's exactly true. Because the day that the verdict came down on, the second trial, the day that the verdict came down, one of the first things y'all asked me with the however many tens of thousands of people we had together was, can she sue law enforcement? The verdict was barely being replayed. And the first thing y'all were asking was, can she sue law enforcement? So this stuns no one, except apparently the civil judge, who was just like, but you gave an interview to today. I don't even know what that was. Of all the interviews that a judge could be mad about, what's the rest of your life look like, Karen? Lawsuits, lots of fucking lawsuits. This is the interview that the judge was so flustered about. I am stunned. Look at everybody's faces. We sure hope you come back now. Nope.
Nope.
That was continues. Karen, Alan, Charles, thank you.
Hey.
Yeah, no, that was just that. I wanted to make sure there was nothing else there, but it's like, surely you must know there are some people on the internet that are mad at you. Sir, what? But the internet. Okay. Sure. I imagine there's people on the internet mad at Trooper Michael Proctor as well. I'm sorry, former Trooper Michael Proctor. Well, I can see why all of you voted to make that side quest, because that was Well, I imagine for Karen Reed and her attorneys, they're like, well, at least New York's close. I mean, hopefully you got some good food. And that the Today Show paid for your transportation, because honestly, if I had paid my own travel for that interview, I think I'd be a little pissed. Like, fully, I wasted glam for this? Yeah, I think that's where I would be. It was an episode. What an odd choice. I wonder who wrote the questions and was like, this is it. This is what we need to do. These are the questions we're going to ask. You get that lawsuit dropped on Thursday and grabbed headlines everywhere. And the questions they asked were, so do you know people are mad at you on the internet? And what comes next? Hate it. Hate all of it. Okay, well, a good reminder of why we do this. This is the anti that. When we get asked if we will do TV and stuff, there are many, well, more than most times that we're just like, oh no, we're so booked. Because the lack of control and the just wildness of all of it is when anyone has depending on the day, anyone has an internet connection, a microphone, and often a computer that works, you can just, tell the world for yourself. Should we go to the afternoon? I still can't understand what the judge was so flustered about with that. It seems like such an odd interview. I wonder what the headlines were, but because the judge said, I read an article about a Today Show interview. I don't know what the headlines were, but Karen Reed says this is her plan. Everybody knew that. That's not. Nobody was shocked by that. Anybody shocked? It's like they said it the entire time. So after the court said to everybody, hey, everybody, happy Monday. Instead of you going off to do your depositions, I'm going to rule later. And the court, let me pull it up real quick. I'm just going to pull up what the court said at the end of his ruling. My in-ears are fighting with me. I love the way that I cut my concert shirt, but it's also a little low in the back for the in-ears. These are EDB problems, not y'all's problems, but problems nonetheless. All right, I'm just going to pull up the docket from the court real quick because I feel that it's only correct to revisit it now that we've seen of what the judge is talking about, which is why we pulled that up, because that's what the judge was talking about. Lizzie Tucker says there's a much better interview. I'm sure there are other interviews. I was just trying to figure out what the court was on about, truly, because I didn't understand what the court was on about. And he references the Today Show. So let's look at what the court said, because the court read his endorsement order into the record. This is what he read into the record. For this case to proceed efficiently and for our system of justice to work, certain basic things have to happen. A subpoena needs to mean something. A lawyer's agreement needs to have meaning. Lawyers need to communicate with their clients. Clients need to keep their lawyers informed. When given an opportunity to provide support for a party's request, that party needs to avail themselves of that opportunity. That's all about Proctor. Based on the record before me, the court wrote, there is insufficient support to delay the deposition going forward. That should have been the period. That should have been the period. 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 Do not continue. Do not pass go. Do not collect $200. That should have been on period. Based on the record before me, there's insufficient evidence to support a delay in the deposition going forward, period. And then, however, However, given the claims made in the filings over the weekend, I will delay making a final decision on the motion until 4 p.m. today to give Mr. Proctor's counsel the opportunity to supplement the record before me. One more bite at the apple, Proctor. One more bite at the apple. The subpoena requiring Mr. Proctor to appear for a deposition today is stayed for 24 hours because the subpoena date was for Monday. Further hearing will be held today at 4:15 p.m. by Zoom. This was from yesterday. I followed up with Attorney Seligson with his reference to strategically preparing for the deposition because I read in the media of an appearance on the Today Show Friday morning where Miss Reed said filing her new civil lawsuit was always a part of a plan she had. And she's already sued the individual officers involved for malicious prosecution. Of course, she's going to sue the departments. Beside her were attorneys Alan Jackson and Charles Waters, who cast the case as a bid to expose institutional corruption in Massachusetts law enforcement and to hold someone accountable for the death of her boyfriend, Officer John O'Keefe. I don't think they said it exactly like that. I do think they said that they, based on the questions, were hoping to expose more of the corruption. Also, and because, as the court said at the beginning, for our justice system to work, what we can't have is institutional corruption. So when we have that brought into the spotlight, continuing to shine a light is the appropriate response. Because for our system of justice to work, you cannot have people flouting our system of justice. They have the power to do that from the inside, is the thing. And that's where the bigger problems are. C.E.G. Murdaugh. When the people inside the system try to impact the outcomes, they should be held to account. And no, I do not think the courthouse Becky has been adequately held to account. And yes, it still pisses me off, but there is little I can do except yell about it on the internet. So they should be held to account. They should be held to account. The court goes on to say, although there is no duty for Ms. Reed's counsel to have informed Mr. Proctor's counsel of the intent to file the most recently filed Bristol County action, I think it unreasonable to have not done so with a scheduled deposition pending. And this is why the court put everybody in timeout. And to have filed such action 4 days before the scheduled deposition. He's not a party to the depo. He's not a party to the lawsuit. How does it change how he prepares for his depo? Everyone knew. Emily, you're repeating yourself. I know I'm buffering. Everyone knew that the law enforcement was going to get sued. Proctor knew what was in Proctor's phone. Okay. The actions by counsel, Mr. Proctor's counsel seeking to continue the deposition at the last moments, and Ms. Reed's counsel filing its new action 4 days before the scheduled deposition with an obviously planned appearance on national television. He calls out both sides of attorneys in this. But then he gives one side more time because he delays his ruling for the rest of the day. And then he goes ahead and quotes the rules of professional responsibility. However, I still stand by my earlier statements that I think the phrase patient firmness should be wandering in to my second Audible account because it is a delightful turn of phrase. However, these are two different circumstances, and it's clear that the court thinks that filing the Bristol action on the eve or the precipice of Proctor's deposition was gamesmanship. However, wasn't Proctor's attorneys filing to delay the deposition also gamesmanship. And the court's already pissed that more depots aren't done. So sure, let's burn an entire day when a depot is supposed to be taken. Let's go back to court. Let's go back to court and see what the fuck. Emily, you're feisty. I know. I am annoyed. I am annoyed. I am annoyed. I am annoyed. Because what even is this? He was yelling at the attorneys last hearing to get their depots done. And then we're on the cusp of getting a deposition done, and the court puts everybody in timeout for an entire day. Which only benefits the party moving for more time, doesn't it? Okay. Back to court. Just back to court. Back to court. Back to court. What I will point out to you is we have some new faces on the Zoom this afternoon. We are back with Attorney Seligson, with Attorney Dan Buck, with Attorney Lincoln Rose for one of the bars, with Matthew Hamill, the attorney for former Trooper Michael Proctor, Aaron Rosenberg, one of Karen Reed's attorneys, Seligson, one of Karen Reed's attorneys. Sarah Shipley, I think, is also with one of the bars. And then we also have Evan Wolk, who was the tech assistant during Karen Reed 2, I believe. So he's down here in the corner. I meant to move me and not the entire screen. My apologies. I've done that badly. But we've got Evan down there on the bottom corner. And then Christina, who is, I don't know which party she is representing. However, we are here before the court tells everybody to turn off their cameras, if their cameras were on, and tells everyone to turn them off. And she is just like, this is ridiculous. This is ridiculous. This is ridiculous. So these are individuals in the Zoom call who are not supposed to be there. And the court goes on to tell them to turn off their cameras. And Christina is laughing, just absolutely laughing about the ridiculousness. So the court says, everybody turn off your cameras. And then a bunch of people turn on their cameras. That noise is in the background. But yeah, the attorneys are just like, what is happening?
All right.
Because it's a public hearing. The court's coming in. It's a public hearing, and the court did not keep the ability for people to turn their cameras on and off turned off. I have no idea how that happened. I have no idea why that happened, but that's where we're at with the court not turning off that ability. So it comes up later in the hearing again.
Court session, please proceed.
I also zoomed past the clerk telling everyone to turn off their cameras.
May I proceed? Please. Your Honor, for the record, Civil Action 2483 CV 0692. This is Paul O'Keefe, individually and as personal representative of the estate of John Joseph O'Keefe III et al. Versus C&C Hospitality LLC, doing business as C.F. McCarthy's et al. Counsel, if you please identify yourself for the benefit of the court, the record, starting with plaintiff's counsel.
Good afternoon.
All right, everybody's going to go around the Brady Bunch squares and introduce themselves. So please let me introduce myself. Now is the time for you to figure out which lawyers belong to whom, starting with Dan Buck, the lawyer for Plaintiff O'Keefe's et al.
Your Honor, Dan Buck with Christina Borante for the plaintiffs.
Christina Borante, who was giggling at the ridiculousness of it all, is also one of plaintiff's counsel.
Good afternoon.
Good afternoon. Good afternoon, Your Honor. Lincoln Rose on behalf of the defendant, C.F. McCarthy's.
Good afternoon.
Good afternoon, Your Honor. Sarah Shipley for the defendant, Karen Reed.
Good afternoon.
Okay, so Shipley is
Good
another
afternoon,
Reed
Your Honor.
attorney.
Damon Seligson for Karen Reed.
We know
Good
Seligson.
afternoon.
Good afternoon, Your Honor. Aaron Rosenberg for Karen Reed.
Good afternoon.
Rosenberg. We've seen Rosenberg argue at a number of hearings. Rosenberg's vibes are my vibes at this. This is the vibes. Like, vibes. Exhaustion are the vibes. It's just like, whole fucking day.
Good afternoon, Your Honor. Attorney John Dilly for the defendant, Waterfall Bar and Grill.
Good afternoon.
Good afternoon, Your Honor. Evan Wolk for Miss Reed and appearing on behalf of Alan Jackson.
Good afternoon.
So Evan is standing in for
And good
Alan
afternoon,
Jackson.
Your Honor. Matthew Hamill appearing for Michael Proctor.
Good afternoon. Attorney Hamill, do you want to be heard further?
Your Honor, beyond what we put on the record earlier today, I believe we're satisfied with what's on the record and the additional materials we've submitted to the court, provisionally impounded.
So what do we learn from that? We learned that in the time between the morning hearing being done and the afternoon hearing beginning, that former Trooper Michael Proctor's attorney has filed something additional. And in the something additional, that is provisionally impounded. In the morning session, the court granted the impoundments. And so in the afternoon session, I imagine that the court will go in the same order asking about the impoundment. Haunted Shadow Legacy, both the Waterfall and CF McCarthy's are defendants. This is a wrongful death action related to a alleged DUI related death. And so the bars that were serving Karen Reed are defendants in this. So that is why the bars are defendants in this. So that is why, for the allegations of over-serving. Those are going to be hard allegations to meet based on what we've seen in the trials, but that's why. You're welcome. I figure, and I always take questions this way, I figure if there is one question, there are probably more, because I know you guys jump into coverage at different parts in the cases. So yes, the Waterfall and CF McCarthy's are still defendants here.
Thank you.
Okay. Before I hear from Ms. Reed's attorney on the issue, does Ms. Reed's attorney want to be heard on the motion to impound the submission?
This is should they be impounded or not. That's
Your Honor, I can tell from the substance of what's been filed that is going to be impounded. So I don't have an opposition to the motion to impound what has been filed this afternoon. But I would like to be heard from on Ms. Reed's behalf on what we discussed this morning.
We'll get there. So I'm going to have a hearing on the issue of impoundment. I find good cause for the same reasons I did this morning. And I'm going to order the attachments to be impounded. So Attorney Seligson, I hear.
All the court ruled is that the additional documents filed by Trooper Michael Proctor are of the nature and type covering the subject matter that makes it appropriate that it should be sealed, which to me indicates it is personal and we've heard in the first hearing related to medical. So I imagine that's that. The sound is difficult given that the court and the attorneys are all at different volumes. So it is, yes, it is challenging.
I'll hear from you on the request in light of the supplemental submission.
Your Honor, the arguments for Mr. Proctor's deposition being continue to change. At first, he was argued to be just a mere witness who couldn't attend because he was unavailable. Then they argued that he was also unavailable for his deposition because his counsel had trials. Now they're arguing.
That was the court grabbing the microphone and moving it out of the court's face. So that's what that was. Actually, the court grabbing the microphone and moving it while Seligson is arguing
that he cannot appear for the reasons submitted in the affidavits. And now we are wondering, based on what was submitted this afternoon, can he even appear? Or are we going to put this over for a couple of weeks so we can get a new date? So I'm a little concerned and troubled by sort of the relief keeps changing. They said in their submissions on Friday and then on Sunday that he knows he has to appear and that he will appear. And now this afternoon, we see something that's more long-term. So I'd like to find out about that from the court and counsel for Mr. Proctor. I'd also like to address, Your Honor, some of the statements that were made this morning by the court and that ended up in your written decision. Your Honor,
Attorney Seligson, you don't need to address that.
Well, clearly he thinks he does, Your Honor. Also, Seligson, I can make some mic suggestions, but whatever computer mic is connected to it's not new. It is not ideal. Nope. The Lawnards just want to hear you. But the court's like, no, you don't need to address it. Clearly the fuck he thinks he does, or he wouldn't be bringing it up.
You heard what I said. You might not agree with it, but we're not here for that right now. We're here we're here for the issue. So do you want to add anything else on the substance of the request before the court?
Nothing on the substance before the court, but I would like an opportunity. I'm compelled to put something on the record to preserve my client's rights, Judge, and I'd like to do that if given the chance, and I would be brief.
Your client's rights were in no way impaired by what I stated. So we're going to move on. If you're all done with the substance of the request.
Okay.
Okay. So, Attorney Hamill, do you want to add anything further?
Your Honor, I'll just add that the relief has not changed in our view. From the start, we have sought to get a new date. Again, we're not seeking to preclude Ms. Reed from taking this deposition at all. We are simply seeking a new date for the reasons that we provided to the court already and the reasons we've already put on the record.
Okay. Does anyone else want to be heard?
I mean, I think Attorney Seligson still has something to say, but you
Hearing from no one. I didn't hear that. I'm sorry.
I guess without sort of running afoul of what you've just said to me, there is a question about notice. You've injected a different type of notice requirement that is perplexing to me and my colleagues about notice of things in advance of depositions, and that's what I was trying to seek clarification about.
Attorney Seligson, the great thing about this process is if I issue a decision, we generally don't engage in a discussion or dialogue about it. You can appeal something if you want to. If you want,
he can't appeal your Seligson. I don't think has the grounds to appeal you saying that they should have given Proctor's attorneys the heads up about the other filing that their client is not a party to. Go appeal it. I don't even think they can appeal it because it's dicta. Oh God. Okay. It's a dicta in an endorsement order.
To seek clarification.
Attorney Seligson, the great thing about this process is if I issue a decision, we generally don't engage in a discussion or dialogue about it. You can appeal something if you want to. If you want to submit something in writing for clarification, but I'm not going to engage in a dialogue back and
do that. Do that. Please do that. Please immediately do that. Please submit whatever y'all want to say in writing because the court just invited it. You can submit something in writing seeking clarification. Please do that. Can we do that? Can we? That please. Yes, please.
forth. That's not why we're here right now.
Understood.
Okay? So, thank you. So I find that the supplemental submission does not provide sufficient support to grant the extraordinary request before the court, which is to continue a long notice deposition, which was scheduled on a date agreed to, and the request, in effect, is made 1 business day from the scheduled deposition. The timing of the request remains a concern. In addition, I am not convinced that the signatory of the letter submitted is qualified to give the opinions contained therein. Even if there had been a curriculum vitae submitted,
Sorry, I totally muted that line accidentally. I just saw your email. Oh, okay. There was one I clicked and I was like, fuck, was that it? Okay, cool.
EDB, who is that interceding on the Zoom call? I have no idea. Somebody who unmuted themselves on the Zoom call in the middle of the court's ruling. But I don't know if the court was cutting Seligson off because he was like, you don't know you're winning yet, but you're winning, so stop it because you're winning and I just want to make the order. But now the court is jumping in saying, hey, everything Proctor submitted is insufficient and there is not enough cause to continue this deposition. So I don't know if the court is trying to cut Seligson off because it's like, stop while you're ahead and let me just rule in your favor. However, the ruling in your favor doesn't really help if it's at the end of the day. I'm going to go back to the court's ruling because I just wonder if that's why the court was cutting Seligson off so much, because he was like, no, I'm about to rule in your favor, so let me just rule in your favor. But it's wild. And then the fact that the court doesn't have the Zoom, a lot of courts have Zoom where the observers cannot unmute themselves, cannot show their screen, and then only the participants that have a special code can do that. But the court's giving us a lot of information about what's in Proctor's submission. And so I'm trying to also take a deep breath with my annoyance and listen to what the court's telling us about what Proctor submitted, including that whatever was submitted, there wasn't a resume of who the person was that was submitting the affidavit. And even if there had been, that might not have been enough information.
I'm not going to engage in a dialogue back and forth. That's not why we're here right now.
Understood.
Okay? So, thank you.
I backed it up because I wanted to hear what the court had to say.
I find that the supplemental submission does not provide sufficient support to grant the extraordinary request before the court, which is to continue a long notice deposition, which was scheduled on a date agreed to, and the request, in effect, is made 1 business day from the scheduled deposition. The timing of the request remains a concern. In addition, I am not convinced that the signatory of the letter submitted is qualified to give the opinions contained therein. Even if there had been a curriculum vitae submitted,
Sorry, I totally muted that line accidentally. I just saw your email. Oh, okay. There was one I clicked and I was like, fuck, was that it? Okay, cool.
All of the lawyers were like, what the fuck? Welcome to high profile cases, attorneys. I'm sorry. At least somebody wasn't trying to stream the audio of some sexy time, because that happened in one of the trials we watched, where somebody was observing on Zoom and was streaming the audio of some sexy time. So there was that. This wasn't that, but the everybody was just like, good Lord. The court's like, what the fuck? And the clerk looks like they're looking for whoever that was.
Even if there had been a curriculum vitae submitted, I am not convinced that it would show qualifications to give such opinions. The opinions are general in nature, do not provide any detail relative to the information referenced, in the first paragraph of the letter. The opinions turn the request to, in effect, a request to continue a deposition indefinitely, which is contrary to what Mr. Proctor's counsel stated this morning. Of further concern is that the opinions appear to be by committee, without all committee members signing on to the opinion.
Interesting.
Finally, the dates in the letter show that the issue before the court could have been handled much earlier. The motion for a protective order is denied. The witness shall...
So, denied, but also the court says, based on what was in whatever letter they submitted, that sounds like it is probably dealing with medical in some way, given that the court is talking about broad and vague opinions, and the court is talking about even if there was a resume, this person's probably not qualified to give the opinions that they're giving, and it seems like they're delaying the deposition indefinitely. But the court is saying, with all of that, whatever the underlying thing is in the letter, it could have been brought to the court's attention much, much sooner. This isn't something that sprung up on Wednesday, Thursday, Friday.
Shall appear tomorrow for deposition at the place and time set forth in the subpoena.
So motion denied. Somebody on Zoom. Motion denied. This is after 4 p.m. on Monday. Motion denied. Show up and be deposed tomorrow. Show up and be deposed tomorrow. And somebody literally ooped. They'll probably get kicked out. And the courts can ban people from the public Zoom calls, which I imagine that they will, try to do if they can figure it out. But motion denied. Go be deposed tomorrow, which, yes, Kate, her fate said, see you this Tuesday, Proctor. See you this Tuesday.
Your Honor.
Okay. Thank you very much, Attorney Sellingson. I'm Polly.
No, that's not me. Somehow the court got muted. Somehow the court got muted. Your Honor, your mic. Look, the judge says Attorney Sellingson and then gets completely muted.
Oh!
Your Honor.
Okay. Thank you very much, Attorney Sellingson. I'm Polly.
He started to say, Attorney Sellingson, I apologize, and then the court's mic is gone. And look at all the attorneys.
Your Honor, you were muted there. We didn't hear what you said.
Look at everybody's face. Everybody's face is like, Your Honor, Your Honor, Your Honor, your mic. Rosenberg's like, the fuck. I think John Deely is going to climb into his monitor. Everybody's faces started facing on this Zoom call right now. It's really funny. Rosenberg's like, what? The court immediately said, Attorney Sellingson, I apologize. And then the mic is gone.
Shall appear tomorrow for deposition at the place and time set forth in the subpoena.
I wanted to watch the faces again.
Okay. Thank you very much, Attorney Sellingson. I'm Polly.
Attorney Sellingson, I apologize. And everybody's such Rosenberg's like, what is happening? What's going on?
Your Honor, you were muted there. We didn't hear what you said.
We didn't hear your apology, Your Honor.
Your Honor.
Your Honor.
We didn't hear, you got muted. We didn't hear what you just said.
Okay. Did you hear anything?
No.
You said Attorney Sellingson, and that was it.
Your Honor.
It was brilliant, I'll tell you that. But Attorney Sellingson.
And now he's trying to make a joke. I think so. Julia said the clerk finally hit mute all. Yeah, too late and muted the judge.
Again, I was apologizing to you if you felt that I cut you off, but the issues you were raising.
Your Honor, you did cut him off. You did cut him off.
Anything?
No, you said Attorney Sellingson, and that was it.
Your Honor,
It was brilliant, I'll tell you that. But Attorney
doubt.
Seligson,
At least Seligson
I was
laughed.
apologizing to you if you felt that I cut you off. But the issues you were raising are not the reason why we're here at 4:30 in the afternoon. All right?
I understand, Judge. There is one issue, just very brief, is the deposition. We appreciate the fact that the deposition is ordered to go forward. And order to go forward tomorrow is problematic. We'd like to get with counsel for Mr. Proctor and get a prompt new date that works for us. This tomorrow doesn't work for our scheduling, unfortunately.
But hang on. I'm going to have the clerk put you all in a waiting room. Can you do that?
So they get to the very, very end of the day. The court gave Proctor all the more time. And then the court's like, go do your depo tomorrow. And Attorney Seligson is like, hey, so we're unavailable tomorrow. And the other lawyers are like, the fuck is happening? The fuck is happening? So the court puts them all in timeout for an entire day, burns the entire day, and then brings the hammer down saying, this is all insufficient. This was brought up way too late. Motion denied. Go do your depo tomorrow. And everybody else is like, so there's like 17 lawyer schedules involved, and what we can't do is do this tomorrow. Continuing on.
You can talk, and when you're done, someone can email the clerk and let them know you're ready. Do you have Clerk Dorman's email address?
Yes.
Okay, so we're going to put you in a waiting room. You can talk about it and let us know when you're ready, and we'll be here. Okay?
Thank you, Judge.
So,
thank you, Your Honor.
But I'm curious if the deposition clearly, given what I've heard about the length of the maybe 3 depositions that took place in this case, isn't going to be done in a day. So why would you have something else scheduled tomorrow? Why wouldn't you just continue until the deposition is completed?
Well, we weren't certain that we would not conclude it tomorrow, Your Honor, but people's schedules just don't allow for it to continue the second day in a row. Obviously, if we didn't finish it, we would suspend and find a date that did work. But to take it off,
the court to me, and I'm sure there are other ways to interpret this, the court to me seems genuinely flabbergasted that the attorneys weren't prepared for this to be a 2-day back-to-back deposition. To me, the court seems genuinely surprised, because I wonder if, and this is my speculation purely, I wonder if the court was like, they know it's going to be a 2-day depo. Everybody I'll wait till 4:15 and then I'll just make them all do it tomorrow. And the court is like, what do you mean you're not available tomorrow? What do you mean you're not available tomorrow? But if the judge wanted it to get done, he should have just made this ruling in the morning, because nothing that Proctor's lawyer said in any of the public facing information was that over the weekend, they were unable to gather the information they needed because it was the weekend. They never said that they needed, Your Honor, just give us another 2 hours on Monday. We can bring you more information that supports our point. They never made that argument or made that request. The court did this sua sponte and then seems just stunned that, what do you mean you all aren't available tomorrow? Well, they're not. And then the court's mad about it, because the court just is going to be mad. So let's hear what the court has to say about, what do you mean you're not available tomorrow?
Well, we weren't certain that we would not conclude it tomorrow, Your Honor, but people's schedules just don't allow for it to continue the second day in a row. Obviously, if we didn't finish it, we would suspend and find a date that did work, but
Which is the worst thing in the world. Why not just schedule the deposition day to day to be continued until it's completed? But I'll leave you to talk among.
Long program, short program, back to back, same day. We're back to the cutting edge. Your Honor, I don't know, man. This is the way their depots are scheduled. But you done fucked up the schedule, and now 15,000 different lawyers have to go check their calendars, which is a shit show all the time. It's a shit show all the time. You try to get 2 lawyers to schedule a thing, it's difficult. 3 or 4 becomes quite challenging. More than 4, you are now in realms of impossibility.
Yourself.
Thank
Let us
you.
know when you're ready.
Thank you,
Now he wants everybody to go talk amongst themselves, and he's going to try to put everybody into a Zoom breakout room.
Finish it. We would suspend and find a date that did work, but
Which is the worst thing in the world. Why not just schedule the deposition day to day to be continued until it's completed?
Because there are
But I'll leave you to talk amongst yourself. Let us know when you're ready.
Talk amongst yourselves.
Thank you, Your Honor.
So now
No, once they come back, I'm going to come back.
they want to put everybody into a Zoom
You gonna get
breakout
all
room.
them in a waiting room?
Or a waiting room, whatever. So they try to put everybody into a Zoom waiting room. And I'm going to let that just play out. I'm going to let that just roll. I'm going to let that roll. So, Morgan said with multi-party depots, how do they decide what order the lawyers go in? They generally can sort it out amongst themselves. The party that's going to have the most questions, I would think in most circumstances would go first. And then if something was not covered, the lawyers for the other parties would cover just those parts. I think it's pretty clear in the depots in this case that the parties that have the most on the line here are the O'Keefe parties and then Karen Reed. And I imagine the bars have their questions that they want to ask, but that those would go subsequent. In different cases, that might operate differently, but I imagine in this case, that's how it would operate. And this is in real time as the clerk is starting to try to put everybody into the breakout rooms and pick a date. LB said, TLDR, Judge, why aren't your depots done? Yeah, this is going to come up when we're down the road and all of the attorneys are saying, Your Honor, we need to extend the discovery cutoff. This is going to come up. This is 100% going to come up. And they had strategically scheduled depositions, as Seligson had said, because there are things they're going to want answered by certain parties before they lock in depots of others. And I imagine the attorneys are all mindful of whether or not these parties are talking to each other after their depots. They shouldn't be, but there is internal strategy on the legal teams of how they are ordering the depositions. So now they are trying to break out.
I'll ask them to do.
I just have to suspect that Christina, who is part of Plaintiff's legal team, is texting. And I imagine those texts are like, girl, this is just what's happening in my brain. Girl, you're not going to believe this shit. First of all, we got here this morning and they're all fighting over everything because, of course, they're all fighting over everything. And then they made us come back at 4:15. So we're back here at 4:15. And then there was a rabbit. And then there was a dude who said fuck about something. And then somebody went, whoop. And then the judge is trying to put us all in a breakout room because he denied the motion, but no one's available for depot tomorrow. What the fuck is happening? That's just what I suspect.
Attorney Rosenberg, what can I help you with?
Damon, you're unmuted.
Yeah, I was just indicating for the room that I was.
The orange nails are cute too.
For you to see who should go in the room.
I like the nail color too. And I love that Rosenberg's like, I'm just trying to help make it go faster today. Rosenberg's like, can you put me in the breakout room? I imagine there are quite a substantial amount of people on this Zoom. And so the clerk going through and trying to find everybody to put them into the breakout room seems like it is causing some challenges. And now everybody's just sitting there looking at one another. No, we're still not fucking done yet. Now we gotta pick a date. I know. Right. No, I'll text you. That's just what I'm thinking. Because that's exactly what I would be doing. And now they're all awkwardly staring at each other in their calendars. This is fantastic. This is fantastic. Fantastic. Emily, you're not zooming. Nope. Because this is so awkward. We're all going to sit here and watch it together. I'm going to pull up some of your comments while we're sitting here awkwardly, waiting for them to get everybody into a breakout room. Yeah. Because we're still waiting. So am I still waiting? Right. Awkward in real time. Can we send the judge a goat and a mini violin? I don't trust this court with sound effects because the wild roller coaster that we were on with this judge today, no sound effects for you, judge. Because I just... oh, there we go. People are going into the Zoom room. All right. Into the Zoom room. There we go. I just see Christina's nails a little closer up. Finally into the Zoom room. Finally into the Zoom room. RK, good to see you. Said topic. Right. Long program, short program. The court's like day 1 deposition, day 2 deposition. You've forgotten someone. Excuse me. There we go. And then the judge sits here on the bench, on Zoom, on the bench, just waiting. Just sits here on the bench waiting for them to all come back. Just hanging out. Just hanging out on the bench. Yep, I'm zooming. I'm still zooming, obviously. They're just chilling. Talking about the Zoom. I don't know what they're talking about. But just chilling. I'm not going to make y'all sit through that in real time. We're going to zoom. There we go. All right. We're going to start.
Mr. Clark, the only issue is when we came back in.
I zoomed too far. I zoomed too far.
Your Honor, we should all be popping back in now. We're done.
Oh, good. Now they're all popping back in. Richard, the magician, great question. Richard said, so do the other parties need to give Reed's team a heads up when they're on their strategy too, or just Reed's team? I don't know.
Mr. Clark, the only issue is when we came.
I think part of the issue for the court was the proximity to the deposition. But no, we haven't seen the court say anything about whether or not anybody would need to give Reed's teams a head up when they go ahead and sue her. No, I think the proximity to the depot was the court's
came back in, our
issue.
video is disabled.
Oh, now the video's disabled. All right, there we go. Good. Everybody's coming. We're all coming back now. It's all coming back to me now. Wait. Nope. Now I'm covering people. Hold on. Are we good? Are we in our final form?
Okay, so we're back on the record. Attorney Seligson, what's the...
So after the Zoom breakout room and the tech and the all of the things, everybody's now back. If they had just done this in person, this would have been so much easier. But here we go.
Result of the discussion.
Your Honor, we were cooperative. We have landed on 2 dates. One is June 25th. We have a status conference before Your Honor in this case, and we'd asked that we could use that date for the deposition of Mr. Proctor. If that's acceptable to the court, that works for all counsel.
How is nobody ready till June 25th?
Mr. Hamill is going to get confirmation from his client that date would work. The other date we have is July 14th. That works for all counsel, and we're going to get confirmation it works for Mr. Proctor.
Okay,
So where are we at after an entire day and 2 hearings? Former Trooper Michael Proctor's motion to continue his deposition for more time got denied. And the way the court decided to do it means that he ends up getting exactly what he asked for, because they're not available to do the depositions the very next day like the court ordered. And so the motion got denied and Proctor got more time. Yep. So there's that.
modify the endorsement to read that the witness shall appear for deposition at the place and time set forth in the subpoena on a date agreed to by counsel.
Yes, that's works.
So,
Thank you, Your Honor.
what depositions do you have on the 24th of June?
This again. The court's back to what depots do we have? What other depots do we have? Hey, Your Honor, they had a depot today and it didn't get done because the court said, come on back at 4:15. Could have done one today. Could have done one today. I don't even know how you explain this to somebody without watching this all go down. So his motion was denied, yes, but he won, yes. So what happened? Everybody got put in timeout. Okay.
24th of June.
The court asked everybody, what depots do you have on June 24th?
There's an ongoing discussion, Your Honor, about Ms. Reed's deposition potentially being on that date.
Well, that's
Okay, what
the Brian Albert deposition, and
Yeah.
that's what we discussed, Your Honor, you and I at the last status conference, that email. So it's just more to come, I believe, on that.
Rosenberg's like, and welcome to the shit show, everybody. Because Rosenberg at the last hearing said, hey, Your Honor, we have all these depots scheduled for the House defendants. Albert, McCabe, Higgins. And I said, y'all have the same lawyer? That seems like a bad idea. But they had gotten an email at like 9 o'clock the night before. And then all of a sudden, all 6 depots or 7 depots needed to be rescheduled. Remember that at the last hearing? The judge was like, what do you mean? So now Rosenberg's like, hey, Your Honor, remember we got that email and all of a sudden all these other defendants who are scheduled for depositions are now unavailable for deposition? Yes, good, right. So Brian Albert's deposition is supposed to be June 24th, but they had gotten the email from the lawyer saying we're not able to do the depositions. Correct. Correct.
What about on the
Right.
26th? What depositions do you have?
On the deposition on the 26th, we have Matthew McCabe, also subject of discussion.
Same
What time
email.
does that start?
That's supposed to start at 10 a.m.
Okay, so
But same email,
can
same
we
problem.
have a status conference at 9:45 by Zoom right before the deposition starting? The timing of it will encourage us all to be brief.
That'll work for us, Your Honor.
Your Honor, you put the attorneys in timeout for an entire day. And now you're like, can we just do a status conference at 9:45 so we can all be brief?
Anyone have a problem with that?
No, Your Honor.
Sure.
No, Your Honor.
Okay,
No, Your Honor.
all right. So we'll note on the docket that the status conference of June 25th has been continued to June 26th at 9:45 a.m.
Thank you, Judge.
I reluctantly say, is there anything else?
Yes, but no.
Okay, thank you.
So for the record, this matter is continued to June 26, 2026 at 9:45 a.m. for status conference. Thank you.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Mm-hmm. Emily, there's music. I did that. I did a thing. I love, by the way, that closed caption came up with "Thank you, Your Honor" with "Thank you, Ariana." Pick your Ariana in the chat. You can pick whichever one you like. Just keep this moment in mind, law nerds, now that we are done with the afternoon session of the emergency hearing on former Trooper Michael Proctor's motion to continue his deposition. Now that we are done at the end of the day, keep this in mind. Put a big old asterisk on this date, because when we inevitably get to argument over why the discovery deadline needs to be embiggened, and the court is feisty with everybody about why they haven't gotten their depositions done, this is going to come back around, I would imagine, because this is going to come back around. So let's do a quick summary before we get to some of the other filings. A quick summary of where we're at the end of the day from yesterday, June 9th, 8th, June 8th, yesterday, June 8th. The deposition of former Trooper Michael Proctor was supposed to take place on June 8th. On Friday, his attorney was like, "Hey, Your Honor, we're going to need an emergency continuance on that because Karen Reed's attorneys are disinclined to acquiesce to your request, and we're going to need to go ahead and continue our deposition." And the court heard the arguments in the morning and then said, "I'm going to give former Trooper Michael Proctor's attorney till 4 p.m. to submit any additional supporting information based on the things said to see if we need to continue this deposition." And then came back feisty and irritated, it seemed to me, in the afternoon, saying, "No, none of this is sufficient. I order you to go to deposition. This is not good cause to continue your deposition. I order you to go to deposition tomorrow at the same bat channel, same bat time, same bat place as the depo was scheduled for on Monday," assuming, of course, that whoever they had doing video, transcription, and whatever location, because I imagine a lot of the law firms' conference rooms might not fit this panoply of attorneys. So also that whatever location they had set up for the deposition to go forward and letting security know and the rest of it would all just be available the next day. The court was like, "Go to deposition on Tuesday." And then Karen Reed's attorney, Seligson, said, "Hey, we're not available tomorrow, so we're going to need to pick a new date." And the court was like, "What do you mean you're going to need a new date? Clearly, this depo was going to take at least more than a day. How are you not scheduled on contiguous days for this deposition? What if you hadn't finished in a day?" And Reed's attorney said, "If we hadn't finished in a day, we would have suspended the deposition and then set it for a future date." And the court was just like, "Well, that seems to be about the worst." I think he said, "That seems to be about the worst way to go about things." Well, Your Honor, you didn't ask the lawyers what the schedule was before you suspended court for the entire day, burned an entire day when Proctor would have been sitting in a depo, and then yelled at all the attorneys about, "Well, what depos do you have planned?" And they're like, "Well, on the 24th, it's supposed to be Brian Albert, and on the 26th, it's supposed to be Matt McCabe, but we got an email from the lawyer for all the House defendants saying that none of their depositions can go forward. So everybody's in a big stalemate of who's going to blink first on getting a deposition done." So now we're in the middle of when's a deposition going to get done, and former Trooper Michael Proctor's deposition's either going to take place on June 25th or July 14th or both. So Trooper Michael Proctor lost his motion to get more time at his deposition and then got more time for his deposition and burned an entire court day doing it. So that all could have been an email, I think. But when I tell you that civil law was not my favorite, Exhibit A, this kind of stuff just breaks my brain. It is incredibly frustrating. An entire day of what are we going to do? Okay, we're back at the beginning, but now we've wasted so much more time. We have to make another plan. Great. That was terribly efficient for everyone. So what happens now? Well, everybody's going to continue to fight over when the depositions are going to take place. Party on. This inefficiency is what frustrates me so much about civil. And I understand with this many lawyers involved. I had one case. I was a research attorney in civil. I did not practice civil a ton because this stuff just makes me absolutely crazy. But I dealt with it all the time as the research attorney for the judge because I was helping write opinions navigating these kinds of discovery fights. And these kinds of discovery fights, I was always just like, oh my God, just pick a fucking date. Children. I do not have the patience to be a preschool kindergarten teacher or a junior high school teacher. I do not have the patience for lawyers fighting over dates. I do not have the patience. And in criminal, the dates are pretty firm there and things can get done. So this all just makes me a little bit crazy. But the way that the judge went about it, whatever that was, and letting the lawyers know that he was annoyed in all directions was wild to me because I understand the annoyance that towards witness Proctor, the court is annoyed because, well, we could have all known about this sooner. Why didn't we know about this sooner? This all could have been brought up earlier. The annoyance towards Reed's attorney that she went on the Today Show seemed out of step with the stuff going on with the calendaring. I think the part of the judge's annoyance was, and now this new lawsuit dropped, and maybe that was part of former Trooper Michael Proctor's filings, that this new lawsuit has something to do with the delay in deposition. But then when we got back at the afternoon hearing, the court said, you could have known about this sooner. So it didn't seem to be directly connected to the new lawsuit. So then why is it necessary to make a point that the court was unhappy with the new lawsuit being filed and statements made in the media? It just seemed unaligned with what the court was frustrated with the lawyers about. I understand if the court's annoyed that the lawsuit was filed and was thus causing a delay in deposition, but that doesn't seem to be what Proctor's side was arguing was causing the delay in deposition. So it was frustrating to watch. And then again, the way it was navigated seemed that the judge, to me, was just relying on the fact that, well, this is probably a 2-day deposition, and this is purely my speculation. Well, this is probably a 2-day deposition, so they can just do it tomorrow. Well, no, they can't just do it tomorrow. And the judge, to me, seemed genuinely surprised that they all couldn't just do it tomorrow. But Lord, is it annoying to watch. That was so fucking annoying. That was so annoying. All of it was annoying. And so when the attorneys are all fighting over needing the time for discovery in Big End, we're going to end up right back here. I'm going to look and see if anything hit the docket this afternoon, because we're going to pull up a few filings that happened during the same thing, or that happened at the same time, that happened at the same time yesterday, and we're going to look at those. But goodness, was that a lot and unnecessary at times. But the court made sure everybody knew what he was thinking, and then did apologized to Attorney Seligson and said, he did say, I'm sorry if you feel like I cut you off. But for a judge, I apologize is, at least movement in one direction, because he did cut Seligson off. And the judge has done that to other attorneys throughout the course of this. But bringing up the media just ruffled my feathers a little bit, because it seems, why are there so many new filings? Shit. It was at this moment when she knew that she fucked up. Why are there so many new filings? Why are there so many? Shit. Okay, everybody. We're not going to be able to get to all of these. Well, that was lovely. Let's get to the ones I was intending to get to, and then we'll go for shit. Then we'll go from there. Here's what I'm looking at. Here's what I'm looking at. There is a new plaintiff's request for compelled responses to supplemental request on document production. So there is a full fleet of litigation over compelled additional requests for production. And so they filed all of that together. We also now have the motion on the protective order from the court that is now formally filed, that we saw that. The filings I was going to pull were a letter from Attorney Rosenberg regarding the status conference from June 3rd. And then we pulled the endorsement. And then we pulled the AM order on protective order. We'll pull the PM order on protective order. And then we will, and then I will just overview, because there is an entire new motion, opposition, reply and surreply. And so all of the motion filing hit the docket together today. Let's look at the court's order first and go backwards. So let's do that real quick. I should have swooped. Let's look at the court's order, shall we? We shall. All right. This is the court's written order that he put on the record from the 4:15 p.m. hearing on June 8th. I find that the supplemental submission does not provide sufficient support to grant the extraordinary request before the court, which is to continue a long notice deposition 1 business day from the scheduled deposition. The timing of the request remains a concern. In addition, I am not convinced that the signatory of the letter submitted is qualified to give the opinions contained therein. This all goes to Proctor's motion. Even if there had been a CV attached, a resume attached, I am not convinced that it would show qualifications to give such opinions. The opinions are general in nature and do not provide any detail relative to the information received or referenced in the first paragraph. The opinions turn the request into, in effect, a request to continue the deposition indefinitely. What this is going to be too stressful or something of that nature would be my guess, which is contrary to what Mr. Proctor's counsel stated this morning. Of further concern is that the opinions appear to be by committee without all of the committee members signing on to the opinion. Finally, the dates in the letter show that the issue before the court could have been handled much earlier. The motion for the protective order is denied. The witness shall appear for deposition at the time and place set forth in the subpoena on the dates agreed by counsel, which means he now needs to be subpoenaed again. So then, that is the written order for the court's order. We'll attach it into the docket in the lounge after stream or tomorrow. Let's pull up the letter that was also, I think, filed yesterday. Either way, it hit the docket yesterday. It is a letter from Attorney Rosenberg, one of Karen Reed's attorneys, regarding the June 3rd hearing that we all watched together last week. That was the one where they said, hey, Your Honor, it seems that everybody now needs a new depot date. Yeah, that's fun. We love that for us. That hearing, when did I cover that? Thursday? Tuesday? We covered that last week at some point. So this is from June. The letter's dated June 6th. The docket stamp says June 8th at noon. Letter from Attorney Rosenberg to the judge regarding the wrongful death case. Dear Judge, is it Gildea? Galeda? I don't. Judge G? But like ain't nothing but a G thing is too flattering. Judge Grumpy at this point. Judge Grumpy. Judge Grumpy. Dear Judge Grumpy, counsel for Colin Albert, a third-party witness in the above captioned case. We heard about this in the hearing that we were watching. We heard a bit of this. Counsel for Colin Albert, a third-party witness in the above captioned case, has baselessly alleged that I fucking hell. Have baselessly alleged that I intentionally misrepresented facts or misled the court during the status conference on June 3rd in this case, and has insisted that I clarify the record. Oh, I wonder what those emails are about. I remember they talked about Colin Albert. They talked about Colin Albert's deposition. They talked about all of the House defendants not being available and there being like an evening email. Let's see what correction of the record must sally forth. I understand that Mr. Albert's counsel attempted to raise these claims in open court at a hearing on another matter concerning Mr. Albert when I was not present, but Your Honor did not entertain the discussion because no relevant motion was before the court. Well, that does sound consistent for this judge. That seems consistent with what we've seen. At the June 3rd conference, as part of a lengthy back and forth with the court about the status of the many depositions in this case, I referenced the 6 depositions that Mr. Albert's counsel had unilaterally purported to cancel at 9:20 p.m. the night before the conference. I remember that. I remember this conversation. I then referred in passing to Mr. Albert's deposition and his refusal to comply with the subpoena my office served on him. I was confused during that part of the hearing because it seemed like he was saying that Colin Albert had not complied with his deposition, but then later they said that the deposition of Colin Albert had taken place. So I was a little confused by that too, but I was more, I guess, confounded by the late evening email saying, by the way, no depots for you. I was more confused by that. The letter goes on to say, when I say that he had refused to appear, it was not to suggest that Mr. Albert took the position immediately upon service of the subpoena that he would never appear under any circumstances. That is not what I said. Instead, I was referring to the fact that the same counsel that sent the 9:20 p.m. email had, on behalf of Mr. Albert, refused to produce documents in response to his subpoena. Oh, I understand where the confusion was. But also, there are times when it's hard for me to know if all the parties in the conference are confused because they're all engaged in what's going on behind the scenes. And so the confusion that is ours on the outside, the attorneys might have all been on the same page with the judge because they're all having these conversations. But same lawyer, same. So Rosenberg is saying that he did not, in fact, say that Colin Albert refused to appear for his deposition and didn't, he says, suggest that. He says, instead, I was referring to the fact that the same counsel had sent the 9:20 p.m. email, had on behalf of Mr. Albert refused to produce documents in response to his subpoena, which, by the way, is part of appearing as being responsive to document discovery and interrogatories and the rest. Let's see, where are we? I was referring to the fact, I keep interrupting myself. It's late. I was referring to the fact that the same counsel had sent the 9:20 email, had on behalf of Mr. Albert refused to produce documents in response to his subpoena, delayed responding for weeks to proposed narrowing of subpoena terms, failed to provide additional reasonable available dates after the deposition was postponed, not canceled, because of the document dispute, emailed in late May to say that Mr. Albert would only be available for 13 days that followed. I remember that he brought that up on the record, after which he would be unavailable indefinitely, and then coordinated with plaintiff's counsel to schedule a new separate deposition pursuant to a new subpoena from plaintiffs, noticed 6 days before such deposition in direct violation of Rule 30b-1. I remember those things being stated. Also, Emily, do the documents matter? Yes, the documents do matter, because if you don't have the document discovery, you can't do a full deposition of someone because you don't have all the information. That's fair. I'm not surprised that they would want to say, well, if you don't respond to the document discovery, we can't do your deposition yet. And then you end up round and round and round and round. And then I remember them saying that there was and now you only have 13 days to do this deposition. When I stated in response to your question that Mr. Albert, quote unquote, refused to appear for deposition, that is what I was referring to. As I told you at the status conference, the conduct described above is the subject of a pending motion to compel, which we will file promptly once we receive Mr. Albert's opposition, which is why there are so many dockets on the docket today, is because the motion gets served on the other party, the opposition gets served, then the reply, and then the court gets all of the documents together, versus other jurisdictions where the motion gets filed on the docket, the opposition gets filed on the docket later, then the reply gets filed on the docket. They group the filings together and then file them all at once for the court, different than other jurisdictions. As I told you at the status conference, the conduct described above is subject to a pending motion to compel, which we will file promptly once we receive Mr. Albert's opposition. But rather than arguing the merits of this dispute, Mr. Albert's counsel has elected to launch false accusations of intentional misrepresentation at opposing counsel and demand clarification. I guess he's now clarified. I do not think this is the best use of the parties or the court's time and resources. However, at Mr. Albert's counsel's insistence, I am providing this explanation. Oh, boy. I really am curious what those emails must have been. The emails back and forth, I demand you clarify for the record, and then Rosenberg just being like, oh, you would like me to clarify? Your Honor, what I meant to say is that when he refused, it's because he wasn't giving us discovery, and then he wasn't giving us dates, and then we only had a small window of dates, and then we didn't have a small window of dates, and then. So let me explain. So the entire email was, this is a waste of everyone's time, but counsel insisted, so I said what I said. Okay, I guess be careful what you wish for on that one. You must clarify it to the court. Is this what you had in mind? The snarkiness of Rosenberg. It's very sassy. Here, let me clarify for you. Okay, so what I meant to say is He didn't refuse to appear for deposition. They didn't respond to the subpoena, therefore causing the deposition to be delayed, therefore causing the deposition to further be delayed, therefore to fall outside the window of when the deposition was available, and we still don't have the document discovery, so we need to file a motion to compel, but we can't file a motion to compel till they give us their opposition. So here we all are. Great. That's great. That's fantastic. Other filings that we saw were the request of Proctor's attorney to impound the documents. I have not gone over this yet. I have not looked at it. I don't know if there is any more detail in this document, but I wanted to look real quick together since, well, we're all gathered here today anyway, before we try to move on from Massachusetts tomorrow, because we're going to try to move on from Massachusetts tomorrow. This was filed June 8th at 2:22 p.m. So in between the two hearings. Let's see. Okay. Motion to provisionally impound additional materials submitted in support of the motion for protective order. And we get very little bit more information about what that is. This is what the court was talking about. Exhibit A is the affidavit of the attorney, Matthew Hamill, and Exhibit B is medical documentation. Based on all of the discussion in court, I am not surprised that it is medical documentation. This makes sense. For purposes of brevity, former trooper Michael Proctor, Mr. Proctor, will not restate the history of the dispute, but instead incorporates it herein. The court provisionally impounded the other documents. The motion is before the court as related to Proctor's separate emergency motion for protective order. These are the new exhibits A and B in furtherance of the emergency motion. I'm still annoyed that the court was like, oh, you didn't get your homework done adequately. Here's more time. They added the case law. We know that this was impounded. I'm just curious if they describe it more. Let's see. It looks like there's a little bit more. My document is fighting with me. I was just trying to embiggen. Oh, too much. Too close. Back it up. Okay. The materials Mr. Proctor seeks to impound contain private information regarding Mr. Proctor's medical condition. Impoundment is necessary given the public nature of this matter and for the reasons stated on the record at an earlier hearing on June 8th. I think matters of medical and civil cases for non-related parties, especially when we're not dealing with personal injury, it's fine to impound them. That doesn't bother me. Impoundment is necessary given the public nature of this matter and for the reasons stated on the record at the earlier hearing. Mr. Proctor is well aware that the, quote, allegations of potential embarrassment or the fear of unjust adverse publicity are not sufficient to support a motion to impound. However, Mr. Proctor is a witness in this case, not a party, and while Ms. Reed, no doubt, has the right to mount her defense, Mr. Proctor has a countervailing and statutory recognized right to privacy. He is a witness here. He's going to be a party elsewhere, or he is a party elsewhere. Let's see. Given the intense media scrutiny this case has garnered, Mr. Proctor's own legitimate expectation of privacy, and for the reasons stated on the record at the earlier hearing on June 8th and in Mr. Proctor's June 7th motion, there's no sufficient alternative to impoundment. We thought it was probably medical. We're not surprised that it's medical. And yes, Chad, it is not lost on me that Proctor felt free to talk about and mock all of Karen Reed's medical needs. Yeah, it's not lost on me either. However, Proctor's behavior in that circumstance doesn't change the way the court views this circumstance, which is where we see morality and legality. Because I understand Chad's like, fair's fair, buddy. Fair's fair. I get it. Morality, legality. Legality, legality. Winged 8. Chat, y'all are I don't know. It's possible. It's possible. Sorry, I said that as Wing. Waiting for Friday said he has a nightstick lodged. It would be a medical emergency. It would be a medical emergency. So I understand where you're at. And in this multiverse of cases, the morality, legality gets hard to parse because we're also dealing with issues from one case to another, to another, to another. I understand. And it is frustrating to try to separate out the fair's fair and karma's a bitch and the different case and legal protections. And though I think my feelings on former Trooper Michael Proctor are fairly well obvious at this point, individuals, taking Trooper Michael Proctor out of it, but within the group of individuals do have a certain right to privacy, especially when they are just witnesses of a case. Otherwise, you could land very easily in circumstances where legal process is used abusively. Not to say that that doesn't happen now, it absolutely does, but the rules to protect that as best they can are valid. However, I also understand that chat is like, boo-hoo. I get it. L in the chat said, am I the only one not seeing member emojis? It is a now known to YouTube issue on mobile. It is a known problem, I think specifically with the iPhone app of YouTube. So it is a known issue. It is not just you. I am also frustrated because there is nothing I can do about it. Right? Which is annoying. Okay, we went over the judge's ruling. We went over the afternoon hearing. We went over the interview that the judge read a headline about and was like, hey, don't do that. Which still baffles me. And we have a new series of motions. Okay, I'm just curious who they're asking for document production from. I imagine it's from Karen Reed, right? I'm just curious what they're asking for. Diller, what do you need? We're just going to take a peek. Chat, give me 10 minutes. We got 10 minutes. Give me 10 minutes. 10 minutes. We're just going to take a little peek. Because why not? We have a new filing. Hold on. You know how the girl feels about breaking news. However, I do love our new filing bumper, and we haven't used it in a really, really, really long time. So if we have to be here in the afternoon, we might as well just take a quick little peek, right? Peter would say we're in overtime. However, it's an EDB stream and we haven't even hit 3 hours yet. So it's not really overtime for us, except it is a part 2 stream for today. This was filed June 9th at 1:32 p.m. I didn't download it yet. That's why it's not, I can't make it do the things I want to. It was filed this afternoon. June 9th at 1:32 p.m. This is plaintiff's motion to compel responses to plaintiff's supplemental request for document production. The plaintiffs are seeking an issue compelling defendant Karen Reed to serve complete responses on the supplemental request for production of documents that were served upon defendant Reed on March 5th, 2026. As of the date of the service, plaintiffs have yet to receive responses, objections, or any requests. Well, that shouldn't be happening. We should definitely have at least a request for continuance or an answer as to why. Let's take a look at what they say the background of this sortedness is. Again, filed this very afternoon. Let's see. Relevant background. This is still plaintiff's motion. That was notice of motion. This is actual motion. Emily said we're going to just take a quick peek. Well, we're quickly peeking. Plaintiff served supplemental request for production of documents on or about March 5th, 2026. Responses were due by April 4th, 2026. To date, plaintiffs have yet to receive any response or request for extension by Reed. This is not the first time we have had to. This is not the first time we have seen dilatory discovery tactics in this case. 1010 for the use of the word dilatory. Great word, underused, here for it. And I don't largely disagree when we're talking about the case writ large, because we have seen all kinds of dilatory discoveries. But it's not lost on me that Diller is the one using the word dilatory in this. This is not the first time we have seen dilatory discovery tactics in this case. On or about July 24th, 2025, plaintiffs served their first set of requests for document discovery. Responses were due within 30 days by August 23rd, 2025. Reed failed to respond or request an extension for more than 2 months, forcing plaintiffs to serve their first motion to compel. Plaintiffs agreed to hold such motion in abeyance upon representation by Reed's then counsel. The production would recur in the next 2 weeks. When Reed finally produced the documents in November and December 2025, more than 90 days late, the production consisted of an incoherent document dump. The production lacked organization, classification, indexing, and even contained hundreds of corrupted and unusable files. So Diller is mad about discovery. And also, if this is all true, yep, this is a problem. That shouldn't happen. Additionally, this production omitted the necessary data and load file. If I have to hear about another fucking load file. We got into the civil case. I thought we were done with load files. They aren't even patiently firm. I'm also curious which files they're having a hard time opening. Which files? Oh boy. Let's see. The production omitted the necessary data and load files required to review meaningfully the electronic discovery. Whose discovery is it, though? Is it Reed's discovery, or is it Reed's turning over of files begot from others like Canton or what have you? I have questions. They're going to cite the legal standard. You have a right to discovery. We're not going through the legal standard today. Requested relief. Tell them to give it to us. They say within 10 days. That was very quick. Let's go look at the opposition. Shall we? We might end up speedrunning it. These motions aren't that long. Let's look at the opposition, shall we? Speed run. Reed's opposition filed this afternoon because they are all filed in a group. Wait, why is this justified centered? Who did that? Don't do that. Don't. No. Do not justify center your motion. What are we doing? No. Okay. Opposition to plaintiff's motion to compel responses to plaintiff's supplemental request for document production. Plaintiff seek an order compelling defendant Reed to serve written Rule 34 responses she has already served and produce documents pursuant to those responses, which she is already in the process of doing. This motion is yet another attempt by plaintiffs to flout the Superior Court rules and use the court's docket to generate dispute and attention rather than working cooperatively in discovery. Oh my God. It's so messy. Your Honor. I mean, also, can we just Is it not centered? It might be my brain. All of you are like, it's not centered. It's just not justified. Thank you. My brain cannot process the messiness. Your Honor, they want responses that we've already given about discovery that we're already in the process of turning over. Stop it. Maybe they will use the phrase clickbait lawyering. Maybe they will quote Diller with the clickbait lawyering. So this is Reed's response on May 7th. Hey, shit, my earring just fell out. That's my birthday. On May 7th, without first conferring with Reed's counsel in any matter, isn't there an obligation to meet and confer? Isn't there a discovery rule motion where you have to talk to each other before you can file it? You can't just file stuff. On May 7th, without first conferring with Reed's counsel in any matter, plaintiffs served their motion to compel responses to plaintiff's supplemental requests. That motion relates to the supplemental request plaintiffs served on March 5th, 19 months after they filed the lawsuit. Reed's counsel inadvertently missed the service email on that date and did not respond to the requests. It got lost in my email. Rather than contacting Reed's counsel and asking about the responses or documents, plaintiff's counsel waited a fully additional month after the applicable deadline and served the motion without comment, 37 minutes before the court's last status conference, in an obvious attempt to use that motion during the proceeding without giving Reed time to respond. Okay, there's a lot of lawyers, though. I agree, chat. Did the email just go to one attorney? I mean, it's fair. There's a lot of lawyers. There are a lot of lawyers. I don't know how it got missed, but also there's a lot of lawyers. Also, that's why the court has obligations. Like, if you don't get a response, you have to reach out and be like, hey, why aren't you responding? Are you refusing to respond? And then you have an opportunity to fix it. The other side is saying, well, you keep ignoring us, so we just assume, it seems, that you're going to ignore us. But yeah, did it just go to one person? Which is possible. Reed's side says, rather than contacting Reed's counsel and asking about the plaintiff's documents, plaintiff's counsel waited an additional month and then filed it 37 minutes before the court's last status conference, without giving Reed time to respond. Less than 2 hours later, after the status conference, Reed's counsel responded by email acknowledging that the responses were due, promised to provide them, and indicated Reed expected the motion to be then withdrawn. See emails between counsel, Exhibit E1. Oh boy. A few days later, plaintiff asked to meet and confer, claiming that the late discovery would somehow impact the then proceeded with depositions in this case. May 11th, 2026, 3:36 p.m. email. Plaintiff thus attempted to use the delay, which they contributed to by not following up on their request or seeking to confer pursuant to Rule 9C prior to drafting and serving their motion, as grounds for future argument to alter the court's discovery deadline. So the delay is being used as a sword and a shield, you would say? On May 18th, 2026, Reed served the written responses the motion seeks. Sorry, my brain read that last word wrong. On May 18th, 2026, Reed served the written responses that the motion seeks. Well, then why is the motion saying that it was never served? On May 21st, Reed's counsel followed up, confirmed that the responses had been served, and indicated that Reed is in the process of producing documents as indicated in those responses, as well as the documents from Reed's cell phone extraction from the Norfolk District Attorney's Office, footnote 1. The Norfolk District Attorney's Office reviewed. No, that is not what it says. The Norfolk District Attorney's Office review has been significantly delayed by the Norfolk District Attorney's Office producing the extraction to all parties in a location other than it had initially indicated. What does that even mean? But also, if Karen Reed's cell phone extraction is in the hands of the Norfolk District Attorney's Office, then could you also ask the Norfolk District Attorney's Office? But okay. Reed is in the process of producing documents, as well as documents from Reed's cell phone extraction from the DA's office. Reed's counsel asked plaintiff's counsel again to confirm that plaintiffs would withdraw the motion, which seeks responses that have already been served and documents that are already being produced. Plaintiff's counsel did not respond. The court should deny the motion and reject plaintiff's latest elevation of gamesmanship over cooperation and the requirements of the court's rules. Emily, civil law. I know. You suck. No, you suck. No, you suck. You didn't respond. Yes, we did. No, you didn't. Yes, I did. Mommy's touching me. Nuh-uh. We need the documents. We're giving you the documents. They're not giving us the documents. We are giving you the documents. They didn't even respond. We did respond. But you didn't respond. But we did respond. But you didn't respond in time. But we did respond. I am waiting for the day that the court comes into court and is like, don't make me pull this lawsuit over. Okay, well, I imagine that the emails are attached. Exhibit E1. Oh boy. Emily, this is going to be quick. There's emails, everybody. There's emails. There's emails. All right. I dropped my lip gloss. Well, chapstick. Emails from attorneys to all attorneys. Christina, come get your boy. He's being feisty. Let's see. This is from Rosenberg to Diller. Mark. Thursday, May 21st, 2026, 5:38 p.m. Mark, we've now served written responses to your second set of document requests, which is the relief you seek in your motion. We are also working to produce documents as indicated in those written responses, as well as the documents from Ms. Reed's phone extraction from the DA's office. We are happy to provide further updated estimate, to provide a further updated estimate next week for the production of any remaining documents. Please confirm that you will withdraw the currently pending motion now that the mistaken lack of response has been promptly remedied. Thanks, Aaron. Emily, you're struggling not to say Aaron. I am. Motion to compel. I sent you a Teams invite. Never. So that Mike Bell can join us. I also sent it to Dan Buck. Dan Buck was funny. Dan Buck was the one who in the last hearing, it was like, anything else from anyone else? And Dan Buck is like, I've learned that less is more in this group. I'm going to sit here and say nothing. Great. Let's see. I'm available at 12:30 p.m. I'll call you then. What is this email signature? Diller! Is this in like Cypress font? What is this? Very truly yours, Mark Diller, ESQ. I hate this font. Emily, we're judging email signatures now. It's late. We're judging everything. All of the technology crashed. Everything will be judged. Let's see. Where are we now with Monday, May 11th at 7:10 p.m.? Where did we start? Were these in order or did I need to go backwards? Oh, yeah. We were on May 21st. I needed to... sorry, chat. We need to start from the bottom. Now we're here. All right. Look, Christina's email signature has a great font. Look at how profesh. Love it. Thanks, Christina. We'll start at the bottom. Thursday, May 7th, 2026 at 2:23 p.m. Good afternoon. Please see the attached motion to compel responses from defendant Karen Reed to plaintiff supplemental request for document production and the attached memo in support. Best, Christina. Response from May 7th at 4:12 p.m. Same day and everything. Mark. When I received this service email 37 minutes before today's status conference, I discovered that I never received the request it refers to. It seems you have served them on the parties but left me off the distribution list. It seems you have served them on the parties but left me off the distribution list. As you know, I have been the one handling the day-to-day discovery matters with you for the last 6 months or so at least. I'm sure this was just a mistake, and I acknowledge that you did include other attorneys for Ms. Reed. However, when you didn't receive a response when it was due at the beginning of April, you didn't reach out to anyone, bold underlined, representing Ms. Reed to ask why that was. You didn't ask when we should expect a response. You didn't request a 9C conference or raise this issue in any of the numerous conversations we have had since then. Instead, you waited more than a month and served your motion to compel just before logging on to the status conference, where I have little doubt you planned to raise the issue. Had you simply asked us why we hadn't responded in April, I would have told you that I never received the request and that we would get responses to you promptly, and we would have done. But instead, you opted to waste another month along with whatever time you spent drafting these motion papers in an attempt to engage in more litigation by ambush. We'll get you a written response to the request referenced in your motion, and I trust that you will then withdraw the motion pursuant to Rule 9A. I really appreciate that Aaron popped off at the partner and not at the associate attorney who emailed this. I appreciate it because it's Diller is the one handling this, and Diller should be, if not directly, should be CC'd on this and is. So Rosenberg is responding directly back to Diller, the senior attorney, and not popping off on the junior attorney, which is appropriate because the junior attorney, it's like, send this off to them. You pop off back at the attorney who's been doing the discovery. And I can understand Rosenberg's frustration because when you are dealing with litigation with this many attorneys, I would suspect that when all the other attorneys get the discovery request, that you're not going to even follow up with them because they're handling it. So why would you even get involved? You're just going to fuck up the email chain. It's like, oh, okay, noted. And I imagine with this many lawsuits and this many attorneys, you're not double checking. If you work for the same firm, you're not double checking that Rosenberg's on it, because why would you? Because if there's a problem, they'll just reach out and ask. So some of you are asking, Rosenberg's in the header. Rosenberg's in the header of the motion being served. This is Christina saying, I'm serving you the motion. Rosenberg is saying, okay, you served us a motion, but I never was emailed the request for discovery. So if you don't email me the request for discovery, I can't respond to your email. You emailed it to some of the other lawyers, sure, but they're not handling discovery. I am. So Claude said, EDB, is this the same Mark that didn't want to delete the email sent by Karen Reed by mistake? That's the one. Same one. Yep. He didn't reply all, it seems, on whatever email. And I'm sure it was an error and not gamesmanship to leave Rosenberg off of the email. But Rosenberg left open the possibility that it was gamesmanship and not just error. Tomorrow asked what happened to that Karen Reed email. The court impounded a copy of the email and ordered Diller to delete it and prove that it had been deleted. So that's the response from May 7th. Aaron, let's meet and confer Tuesday or Wednesday. Let me know your availability. Very truly yours, Mark Diller. Font choice. That email was on Sunday, May 10th at 10:08. This email's May 7th, and then he gets a response on Sunday at 10:08 p.m. You know, you can schedule emails to just send the next morning. The lawyer heroics of, look, I'm working at this on ungodly hour. We just all see it as a lack of boundaries. It's not a badge of honor. It's a badge of burnout. Nobody's brains operated well with burnout. Julia said, oh, he's Mark with a C. He's Mark with a C, but maybe his band is Mark with a K. Perhaps. Monday, May 11th at 12:48 p.m. Rosenberg responds. What are you proposing we confer on? What are you proposing we confer on? I said below that we will respond to your request, which is what your motion asked for. I'm always willing to talk, but I want to know the subject. Maybe, Aaron, he just misses your face. He just misses talking to you. He just wants to have a chitty chat. What do you want to meet and confer on? We're giving you what you're asking for. What do we need to talk about? Thank you, chat. I appreciate you. I also appreciate Rosenberg's like, do we really need a call? We're responding. May 11th, 3:36 p.m. When was the last one? May 11th at 12:48. May 11th at 3:36 p.m. I'm not withdrawing the motion at this time. We can have a meet and confer to discuss whether we can resolve how to deal with the late discovery. We need to proceed with depositions in this case. Okay. May 11th at 7:10 p.m. Rosenberg to Mark. Happy to talk if you think it'll be helpful at this point prior to receiving the written responses. Sure. Because what would happen if Rosenberg says, can you just wait till the written responses? Diller would go to the court and say, and they refuse to have a meet and confer. There's nothing Rosenberg can really do because then it'll go back to the court. He refused to meet and confer. Sure. Happy to talk if you think it would be helpful at this point prior to receiving the written responses. I'm available tomorrow between 1 and 4 p.m. or Wednesday between 10:30 a.m. and 4 p.m. For the record, however, you served these lengthy document requests, which cover topics you have been focusing on in arguments and pleadings in this case since the beginning on March 5th, 2026, 19 months after you filed the case and almost a year after the stay relating to Ms. Reed expired. The fact that Ms. Reed's written Rule 34 responses were a month late because of an oversight has not impacted your ability to prepare for depositions. Oh, well, there's that. Stop it. Because Rosenberg can see where this is going. But Your Honor, they didn't give us the documents, so we can't do the deposition. So we need more time in discovery because the depositions. Tuesday, May 12th, 7:41 p.m. So what, a full day later? Because that last email was sent at 7:10 p.m. Full day later at 7:41 p.m. I'm available at 12:30 p.m. I'll call you then. Very truly yours, M.Dill. Wednesday, May 13th, 11:37 a.m. I sent you a Teams invite so that Mike can join us. I also sent it to Dan Buck, A.Rose. And then we got the last email as well. So you can see why all of this is taking so long. Didn't Rosenberg say between 1 and 4? I think so. But are we surprised that there's more posturing? I'm available between 1 and 4. Great, I'm available at 12:30. I'll call you then. Oh, no, on Wednesday, he did say between 10:30 and 4 p.m. So was this was emailed on Tuesday referring to Wednesday. So yeah. Music to my soul said the Hamilton reference M.Dill. I saw the chat already saying it and I was thinking it too. And I was so glad y'all were on the same page that you would know that I was referencing Hamilton and not making fun of the attorneys for the inevitable infinite loop of nuh-uh you. We might have to rename the pickle M.Dill though. Oh my goodness. Nuh-uh you. Nuh-uh you. Can we meet and confer? Fine. About what? About the documents you haven't turned over. We're turning them over. But what about the documents? We're turning them over. But the ones you haven't turned over, we're turning them over. If you enjoy fighting over email, civil law may be for you. Diller responded, Emily, we're not going through the entirety of these legal filings, and now we are. Because that was the opposition, and the opposition had the emails. So it's only fair to do the reply, because it's only fair to include the reply. And now I'm invested. We're just going to do it real quick. I'm invested. Now we're at the reply. So now we've actually covered the entirety of the new filings. Filed this afternoon, plaintiff's reply to defendant Karen Reed's opposition to plaintiff's motion to compel responses to plaintiff's supplemental request for document production. Oh, Diller. We're going to try to be sassy. While Reed's opposition is replete with excuses and attempts to shift blame, it fails to articulate any cognizable legal or factual basis for the court to deny plaintiff's motion. The reasons they set out is that the relief requested is moot because they're already turning it over or have turned it over. Mootness. But go off, I guess. This omission is unsurprising, and no such basis exists. Reed concedes that her responses are overdue and acknowledges her prior commitment to produce the requested documents. Notably, however, her opposition nor the accompanying email exhibits identifies any firm production date or defined time frame for compliance. You didn't talk about it on the meet and confer? Because he said at the end of the week, I can let you know the discovery rules and deadlines they impose serve an essential purpose. Reed's assertion that plaintiff's timing in filing the present motion was intended to support a future argument to alter the court's discovery deadline is both unfounded and illogical. To the contrary, plaintiffs extended additional time to Reed as a professional courtesy in an effort to secure voluntary compliance with her discovery obligations. Reed's position as set forth in the opposition. Reed's position as set forth in the opposition is that they're turning it over, but okay. The same professional courtesy you extended when you refused to delete the emails or not? Extended additional time to Reed as a professional courtesy. Is it because you forgot to include the discovery attorney on the email or no? In an effort to secure voluntary compliance with her discovery obligations, which it seems like she's doing. Reed's position as set forth in their opposition underscores the necessity of judicial intervention. How? Oh, they actually addressed the mootness. Emily, keep reading. Plaintiffs require the court's assistance to compel Reed to produce all responsive documents by a date certain without further delay so that plaintiff may endeavor to meet the existing discovery deadline. Reed's written responses, standing alone, are of no practical value absent the corresponding document production. As there is no genuine dispute, the court should allow plaintiff's motion and order Reed to produce all documents forthwith. Plaintiff's motion to compel is not moot. Reed's opposition asked this court to deny the motion on the grounds that Reed has now served the written responses that plaintiff sought. See Exhibit A. Do you really have to attach the opposition as an exhibit? The court has the opposition. Is this required by the rules? Because it seems like a waste of like PDF editing. This argument ignores that written responses are one half of the responsibility of responding to requests for documents. They say that they were giving you the documents. On May 21st, counsel for Reed emailed the plaintiffs the following. We've now served written responses to your second set of discovery requests, which is the relief you seek in your motion. We are also working on producing documents as indicated in those written responses. Are we all having different reading comprehensions? I feel like we're all interpreting the same sentences differently. Because the written responses include that the documents are being produced. So they say that they are working on the documents from the phone extraction. Are there other documents that are not getting turned over then? They go on to say Reed's belated service of written responses, which was prompted only by plaintiff's motion to compel, does not moot the motion. As of the filing of the reply, plaintiffs have not received complete document production in response to their supplemental requests. Without a court order establishing a date certain for document production, plaintiffs have no assurance that Reed will complete document production in a reasonable time frame. Reed's vague promise to provide further updated estimate next week is insufficient. The motion to compel, therefore, remains live. Plaintiffs were under no obligation to chase down Reed's overdue responses. Well, after yesterday's hearing, the court seems disinclined to give a shit whether somebody is obligated or not. In fact, what did the court say literally yesterday? Hold on. Let's get back to what the court said literally yesterday. That, let's see here what the court said about everybody working together and giving one another a heads up. The court said that although there was no duty for Ms. Reed's counsel to have informed Proctor's counsel about the intent to file, the court thinks it's unreasonable because it was so close to the deposition. And the court goes on to say that an advocate can present the cause, protect the record and subsequent review, and preserve professional integrity by patient firmness, no less effective than by theatrics. And that the kind of core of professional responsibility is civility in the legal profession, generally defined as treating others, opposing counsel, the court, clients, and others with courtesy, dignity, and kindness. So this was yesterday. And now Diller is just like, but Your Honor, it's not moot. We're under, I'm sorry, where is it? Nope. This one? No. Last one's the charm. Of course it is. Plaintiffs were under no obligation to chase down Reed's overdue responses. But you are obligated to meet and confer before you file the motion, are you not? Am I mistaken? I mean, I might well be. It's late. Reed's opposition criticizes plaintiff for waiting an additional month before filing the motion to compel. This argument turns the discovery rules on their head. It is not plaintiff's burden to repeatedly contact opposing counsel and remind them of their discovery obligations. Well, once they've not met the deadline, though, isn't there an obligation? Like, we're parsing words at this point. Isn't there an obligation to meet and confer prior to filing the motion to compel? Hey, y'all, you were supposed to respond to discovery. You didn't respond. Must we go to the court, or will you just respond? You are parsing the words. Rather, they say it is Reed's affirmative duty to serve timely responses. Plaintiff's decision to wait an additional month before filing the motion to compel reflects the professional courtesy that Reed's opposition suggests was lacking. waiting an extra month without saying, hey, y'all, are you responding? When they have not said to you that the discovery is outstanding doesn't indicate that they're delaying. It indicates more that they're not aware. No, Your Honor, it was a professional courtesy that we waited a month without saying anything to them. Moreover, Reed's suggestion that plaintiffs should have contacted counsel before sending the motion to compel ignores the practical reality. When a party has completely failed to respond to discovery, there is nothing to confer about. Isn't there like a 9A obligation? Rule 9C. A Rule 9C conference is designed to narrow disputes, not serve as a reminder service for opposing counsel's missed deadlines. Reed's history of discovery delays warrants court intervention. Reed's failure, he was starting to talk about this and the court cut him off numerous times. So here we are. The airing of grievances. Diller is going to have the airing of grievances one way or another. One way or another, airing of grievances. Reed's failure to respond to the supplemental request for document production is not an isolated incident. The record in this case reflects a persistent pattern. We love an alliteration today, don't we? A persistent pattern of discovery delay necessitating court intervention. July 24th, 2025. Plaintiffs served the first set of requests for production of documents on Reed. He tried to do this and the court cut him off. August 23rd, 2025, responses were due, yet none were received. October 10th, plaintiffs served motion to compel after more than 2 months of silence. October 18th, Reed served written responses with no documents attached. November through December, Reed produced approximately 650,000 files in a disorganized production with no indexing. That sucks. I have questions about all of that discovery, but yeah, that sucks. That's a lot of documents. March 5th, 2026, plaintiffs served supplemental requests for production. May 7th, 2026, plaintiffs served the instant motion to compel after receiving no response for over 60 days. This pattern demonstrates that Reed will not comply with her discovery obligations absent court intervention. I'm sure the court is going to be thrilled to discuss this. An order from this court is necessary to ensure that Reed produces the documents that she has promised and does so within a reasonable time frame. They ask for the court to grant the motion and compel Reed to produce the documents within 14 days. Mom! And then they attach because they just wanted an exhibit. They just attached the response. I'm not going through all of this response, but another day. My sky is grumbling again. I'm not going through all of their document responses. Oh, there's more emails. I'm definitely going through those, though. The discovery responses, no. Emails, T. Yes. Wednesday, May 13th at 11:37 a.m. From Rosenberg, no. What in the world is that? Who's looking into Home Depot? Oh, that's old. What in the heck? Oh, one of the emails as I was trying to embiggen, one of the emails opened my email program. Fantastic. But it is also the exact same email. Corporate would like you to identify the difference in these two pictures. They're the same picture. Wednesday, May 13th at 11:37 a.m. I don't know why these are clickable. That's the worst. I sent you a Teams invite. And then May 21st, we have served the responses. Can you please withdraw the motion? Great. Why do we need the same email? Why do we need the same email? Well, despite my earlier protestations, the late night crew has been treated to a new filing alert, and we went through all of the filings, which can be summarized as such. Respond to our discovery. Hey, so I'm the attorney handling the discovery and you left me off of the emails, so I didn't see it. We're getting on that right now. No, that is insufficient. Okay, well, can't time travel back into the past and do it then because I'm now aware of it now. So we're going to be responding to it now. Insufficient. Your Honor, make them give us a date. Though the email said, hey, we can give you a date on those documents next week. Insufficient. Give us a date now. Okay. So the lawyers are still fighting over discovery. Discovery is a necessary and tedious process. And if anyone wonders why, civil litigation takes time and is expensive, there you go. And if you're asking yourself, isn't this motion moot? Well, the plaintiffs do not think it's moot. The plaintiffs think that if the court does not order the documents turned over, which Reed's team seems to acknowledge that all the documents need to be turned over and that they are working on turning them over, well, it seems that they think that the court is going to say, yes, do it within 14 days. I guess we'll see what the judge does because we can see the trajectory. We can see the trajectory that they are all going to be fighting much more over discovery and that they are going to, down the road, all be back in front of the court complaining about this because Diller tried to air these grievances at the last hearing and the court was like, not today. Not today, Diller. So they're fighting over discovery that everyone agrees is getting turned over. That's what was filed today on the docket. They also filed the compliance with Rule 9C and the full notice of the filings. So there we go. But we were treated to some more sassy Rosenberg writing. And, you know, Diller was trying with some sassy writing. His falls a little flatter sometimes, but he was definitely trying with some sassy writing. So, you know, we love a little bit of sass, but God, I hate the font in that email signature. Like, what in the 2001 email signature is happening here? And you know what? It might not have been updated since then, to be fair. I don't regularly look up the attorneys on the cases that we're covering, so I have no idea and I don't know the bar numbers in Massachusetts. In California, I can kind of tell vis-a-vis just knowledge of where the bar numbers are roughly when people became attorneys. I have no idea if Diller has been an attorney since then or not, but God, it's awful. Just awful. Can we agree that font matters? that one is a no for me. So bad. All right. Well, maybe if anything happens, Diller will change the font on his email signature. Also, it's just odd to me when lawyer email signatures are very truly yours. It's strange. It's just strange to me. We're going to speed run some questions real quick. I hope that going through that last filing was enjoyable. I hope so. Let's chat real quick. And then I've got to bounce or we're not going to have a stream tomorrow because I still have to do stuff for stream tomorrow. But we did get some sassy emails and we did get to play our new filing bumper, which we never get to do. And we're just at 3 hours and everything seems to be running. Do I say it out loud? Seems to be running kind of smoothly. And late night chat, you get the answers first. A lot of you are asking, where are we going on Wednesday? I think we have to go back to Utah. Utah, give me 2. I think we have to go back to Utah tomorrow. There's a lot going on in Utah. And there's some stuff in Utah I want to talk about. We're gonna have to leave Mass. There's some stuff in Utah I really want to talk about. So Utah, give me 2. We're gonna have to go back across the country to Utah tomorrow, you guys. There's some stuff. We're gonna have to go to Utah tomorrow. Don't worry. Kier said, Emily, I need miles. Well, you're in Massachusetts now, so we're gonna have to go to Utah. We're all gonna have to go to Utah. So all of you are asking, is it Corey? Okay. I'm not gonna have enough time to get to super chats if we give a preview of tomorrow. I'm going to do my shortest preview of tomorrow. But the temporary restraining order in the Bricks and Minifigs Reckless Ben sitch is one of the craziest fucking TROs I've ever seen. And we have not had a chance to get to the TRO yet. And so for those of you that are like, what in the Bricks and Minifigs? I am going to give you the best, briefest background of that case that I can tomorrow morning, but we have to go through the TRO. The TRO is fucking crazy. And we're going to go through the TRO. We're going to go through I think there's criminal protective orders as well. So we're going to go through the protective orders. We are not going to have time tomorrow to get into all of the litigation, all of the police wildness. But I think that getting into what the TRO says and what the criminal restraining orders are and what the criminal charges are, I think will be helpful. Because I think there's some misunderstandings about what is in there, what isn't in there, what's normal, what's not normal. And so we're going to get into the law of it. So it's going to be a lot. And I have been keeping an eye on this case, but the law regarding the temporary restraining order and the criminal restraining orders, I think will be helpful. I am not going to yet get into, and for those of you that are like, Emily, what the fuck are you talking about? The Bricks and Minifigs Lego situation has tentacles of litigation. We will overview it tomorrow. There is a YouTube creator involved. Those videos have been going viral. There is police body cam footage that is wild. There are a lot of misunderstandings. And when we look at the beginning of the whole thing, it started with a consignment agreement like, hey, you can have this property, you can sell it, and then we split the proceeds per a contract. Where that all started is also legally steeped in quite a lot of it depends on this, it depends on this, it depends on that. So we're not even going to get all the way back tomorrow to looking at all of the franchising consignment stuff. I hope to get to that someday because I am interested. There's like an entire year of law school business associations wrapped up into the franchising and the consignment and the agreements and a changing of hands / corporate takeover / the new owners worked for corporate and now they don't work for corporate, and are they really subsequent purchasers and are they obligated to take on the prior contracts? Or there's so much there in the first one, but the TRO stuff I'm really interested in because the temporary restraining order, I have not seen a judge issue a temporary restraining order like this, maybe ever. The backstory of how we all got here is going to have to be another day. But the TRO stuff and the criminal stuff, we have a realm that I think it can help explaining it. Because the judge, the TRO is wild. The TRO is wild. So for all of you that are like temporary restraining order, yes, temporary restraining order, like we saw in the Taylor Frankie Paul case, but this one is crazy. It's crazy. Does this affect all Bricks and Minifigs or just Utah? The lawsuit going on in Utah just impacts the parties involved in the case in Utah. But the Bricks and Minifigs other locations, I think, are being impacted by the fact that this is all in the news. But the parties in the Utah litigation are only the parties in the Utah litigation. Carl said, wait, that's in Utah. I thought it was Oregon. It started in Oregon. It is in multiple jurisdictions because Bricks and Minifig corporate and the individuals involved in the ownership of the, and I have questions about ownership, but involved in the Oregon location are Utah residents, and the actions happened in Utah. Ms. Scarlett Hall said, how could Ben not have gotten a lawyer yet? I have no idea. Lawyers need to be involved because there's a lot going on. There's a lot going on, but lawyers need to be involved because there are some serious repercussions that can happen, and there are mistakes that can be made that impact everything. But there are, I think we can narrow the scope tomorrow to the TRO because we need to go through that. The TRO is interesting. And yeah, we have done a really good job, I think, together. And you have done a great job of allowing me to say when we are closing the scope to what's going on in court, have allowed me to kind of close the scope of what's going on in court. Tomorrow is going to be difficult because there is so much outside the scope of just what's going on in court. And it is hard to narrow the field of focus when there is so much happening outside of court and happening so prominently on the platform. But we're going to have to narrow it down, or we will be here for a week and a half trying to parse it all. And I think we can narrow it down to what's going on in court for sure. So that's what we're going to do tomorrow. But there's a lot going on outside of court, and most of it's playing out on the platform. If you're interested, you can put Bricks and Minifigs or Reckless Ben, the name of the YouTuber, into the YouTubes and find quite a lot of information. But there is also stuff that, as I have been watching it play out, that has been misrepresented. There is information that is confusing. There is information that is not accurate. And I feel that our best use of time, because it's our time, is to go through the legal documents and see what the law says. We got to go see what the law says. And we got to talk about temporary restraining orders. Because remember, those are granted ex parte, which means one side goes in and says, hey, Your Honor, this is happening, and then they can get a restraining order. And we have seen some pretty wild injunctions, but they normally have hearings, and there is a hearing set in the TRO for the 22nd. And so I think the TRO will give us kind of enough context to talk about. And we will be in Utah covering temporary restraining orders because wild. All right. So let's see. We're going to get through a couple super chats, and then I have to go, or we're not going to be prepared for tomorrow, which we also have to do. Camilla said, I hate the email signature font. Doesn't his firm have a set style for everyone's email? I don't know. Shouldn't they? That's what my work does. One would think. That one just, it does not instill confidence. It is not a confidence instilling font. It is very much a what the fuck? What the fuck is that font? The Danish doll said, ready for the audacity. Today has been all the audacity. KLV said, happy Tuesday. EDB, hope T is settled well with the Cavaliers. He's been doing laundry regularly. I worry that he's not eating enough. He is having a blast. He loves the show that they're doing this year. It has not been announced. He loves the show, and he is excited. And that's, one can't hope for more than your kid being happy with what they're doing and excited. And I've gotten to talk to him a number of times, which is great. And I benefit from the fact that T and I are both kind of night owls. So there's times when he's kind of winding down for the night. He was like, I'm surprised you're up. I'm like, well, buddy, I'm the night owl around here. If you're up early, you need to call your dad. But if you're up later, you need to call You need to call your mom because I'm the one who's up at night. Katie K said, I love your channel. Thank you for what you do. Very much appreciate the sassy education. Sass may vary depending on the thing we're looking at, but yes. And civil law is just, well, so much of it is wild. And so much of it is wild. So Just Monet said, Lord, Proctor, sit down somewhere. I mean, Proctor trying to argue whatever he is trying to argue that he can't do his deposition after knowing that this day was coming for so long it just seems ill-fated at this point. It just seems ill-fated. Carrie said Proctor's texts are going to bring down MSP and CPD. Proctor's text and his inability to rehome them. Yes, both of those things, because I suspect that a lot of the phone rehoming had to do not specifically with the Karen Reed case, and this, until I see something else that changes my mind, this is kind of my mind on this, is that I think a lot of the phone rehoming had to do with not just Karen Reed or John O'Keefe, but also the greater multiverse of what might be on the phones, including when we saw other Albert from Canton get in trouble for the dude where's my gun incident that all came to light because of Proctor's phone. Yep. So Donna said earlier today, loving the nails. Emily, thank you. We updated them. We've got new nails. They are very fun, or I think they're fun. I mean, I guess you can tell me if you think they're fun, but we got new nails today. Very excited. They'll be very shiny in the sun tomorrow when it is light again. The virtual juror said, I'm curious, what do you think about them not being able to do the depo today? Do we think AJ got on a plane back to California? I think that the lawyers and the court all didn't anticipate each other well. I think that I might have tried to move heaven and earth to try to make that depo happen, to just be like, that deposition's happening. But also, I understand when you're dealing with that many lawyer schedules, that's not always possible. And the lawyers involved in this case know well more than we do. So all the way around, it is frustrating. Dawn of Aquarius. Emily, do you think the judge will extend discovery? I think the judge will wait to the 11th hour and begrudgingly extend discovery if necessary. But I think the judge will use a very firm deadline to try to push everyone to get things done at the last minute. And then if the judge has to, they have to. And I think that that's probably where we'll end up, with them having to extend discovery. Chronically Imperfect said, happy 40th birthday to me and happy birthday to all of us. Geminis, happy birthday. Happy 40th. 40's amazing. I think 30's also amazing. I love it. I mean, my hips hurt more than they used to, but I love the settled and groundedness that comes with aging. I do. I enjoy it. Also, I'm very much a Taurus. I like being settled and grounded. So I dig it. Hasley OG said, I met Robert Alessi yesterday. I still can't believe it. EDB, I told him I was listening to you. I am so glad. I still haven't gotten to meet Mr. Alessi in person, just over the screen, but he just seems like a delightful human being. So I hope that it was fabulous. I'm sure that it was, because he truly just seems like a delightful human being. I think it's fantastic. And I'm so glad you guys met. And I wonder what he thinks of all of this, which he cannot comment on publicly, but I just wonder what he has to think watching all of this fuckery continue to unfold, because it is fuckery, you know? And also, it's got to be wild watching the things that I can only imagine, assumed to be true, starting to play out. Because I'm sure Karen Reed's attorneys all believed that there was more on Proctor's phone and everybody's phones, and might have believed some of what that contained. And then to see it in a phone extraction and just go, holy shit, it's all real, is wild. Victor Man, thank you so much for the gifted memberships, and everyone who gifted memberships. Welcome to all of the new Law Nerds. To those of you that are on iOS, you will have emojis if you are new members. I just don't know when that is. Maybe I should get a motion to compel. Your Honor, since you want to compel things, can you compel YouTube to fix it? I would love that. Andrea, good to see you in the chat. Hi, Emily, Anorexia Recovery. So proud. Go me. Good to see you. I love that you keep us up to date on your recovery, and so many keep us in the loop on their recovery. The Law Nerds are always here to cheer you on. We understand recovery is not linear, but also thank you for sharing it with us, and thank you for being here. I'm glad you guys are here. So many are in recovery in all their own ways in the chat. And I love that you keep checking in with each other. You guys are so compassionate. And you guys are so kind in the way that you check in and take care of each other and encourage each other. It's special to see, and I really appreciate it. I really, really do. I love this community. It's great. I love watching y'all root each other on. Caitlin said, listening while preparing for teaching SFSTs to Academy tomorrow. Thank you for helping me prepare. You're welcome. And have fun. Enjoy. That sounds like a lot of fun. Teaching is great. So it is fantastic. The artist formerly known as Trooper Proctor. No, just former Trooper Proctor. Just former Trooper Proctor, because Prince deserves better. Truly. Brandy Rose said it was a nail appointment, wasn't it? It was. We cannot miss a nail appointment. It will throw off everybody's books. And I've got a schedule around when graduation was and when I'm traveling to go see DCI. And so, yes, we can't throw it off. We can't throw it off. And we were going to be done with stream if everything hadn't popped off, and then it would have been nails, and then I would have gotten to work for the rest of the evening. But no. Thank you, Casey Cat, for the 10 gifted memberships. Law Nerds, and we have a huge gift of memberships that just came in. Dotted Starfish, thank you for the 50 gifted memberships. Well, welcome to the entire chat of members. Welcome to all the new members. Thank you for that. That's incredibly generous. I appreciate it. Thank you. Music to My Soul. Did you see it was announced today? No. This and tech issues have been it today. Did you see it was announced today that Nick Reiner is trying to access his trust money to rehire Alan Jackson? I don't think that that's going to work given the nature of the charges, because, well, actually, if it's a trust and not an inheritance, there may be some quirks to that. But if the trust is a pour-over trust coming from an estate, that could be really difficult, because if you are accused of killing the person who you are inheriting from, well, then we're going to end up back like we did with the Corey Richins case. So it depends, I guess, if the trust is already funded or if the trust is funded from inheritance in like a pour over. So there are some questions there. But no, I did not. I am not surprised. And I guess we will look at it. Maybe Monday, maybe for the podcast. Yeah, we might take a look at it, but it's going to depend. And I have not looked at it yet. That Weather guy said, you know how much I love Weather, said, can Proctor's team be sanctioned? Not at this point, because the court gave them like a timeout that ended up benefiting Proctor at the end of the day. So, it's just. Let's see. The other Dr. B said making sourdough bread with EDB this evening. I hope it's great. I'm sure maybe we had enough time, maybe not. Leonard Amber said, dang, time flies when you're flying EDB Air. Yes, it does. We just zoomed. Law Nerds, with that, I know we're not going to get to all of our thank yous today. Thank you so much. Thank you for all of our super chats. SawX fan said 100% correct, EDB. State cops are full of scandal. Yeah, it's something that those locally have said multiple times to me when we have talked about stuff. And so that whole interview was just weird. It was just a weird interview. And I don't know. I'm sure that all those involved were sitting there going, what the fuck is happening right now? Like, what are we even doing? So it was a strange interview. Law Nerds, we may be a little bit later tomorrow. I imagine our case brief will be bounced back and maybe after stream tomorrow, just depending on editors because we stream so late. So I will keep you posted in the Law Nerd app, but we might bump back to accommodate for me finishing up prepping for tomorrow because there's some other I need to check dockets and make sure they're updated because all of the things today. So with that, we will be back tomorrow. We will be going to Utah. Y'all got a sneak peek of what we're talking about tomorrow. At this point, whatever pops off, tomorrow, Utah, give me two. Tomorrow, we're going to Utah. We're going to talk about crazy ass TROs. We're going to be in the civil and criminal docket tomorrow, but all in one case. And then we'll see where we go from there in the rest of the week. But tomorrow, Utah. That's what we're doing. I appreciate all of you. Thank you for being here. Thank you for being Law Nerds. Thank you for the extra stream today after our unceremonious yeeting by my computer earlier today. Things do seem to be running better. So hopefully that stays. And I will see you guys tomorrow. Stay tuned in the app. As I said, I will keep you updated on time, but we might bump back a little bit just to give me a little bit more room to pull some more documents and to give the team a little room to finish up the things we need to finish up. Law Nerds, you're the best. Thank you for being here. Good night. Take care. I'll see you tomorrow. Get some rest. I know I'm going to. Definitely need it. Bye, guys. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android so I can keep you in the loop because you never know when something's going to pop off. Thanks for being here and thanks for being a Law Nerd.